therefore to invite you to be there and request you. There is an invitation and a request. Have a blessed deliberations. Yes, Honorable Namanya.
Thank you so much, Madam Speaker. On your communication on Uganda National Bureau of Standards. Madam Speaker, we are always battling with funding gaps here in the country. Uganda National Bureau of Standards is one area when we invest heavily in that entity that we should be able to reap much from it. Madam Speaker and colleagues, Uganda National Bureau of Standards is heavily facing challenges from human resource, from funding, and therefore it has costed many Ugandans who are in manufacturing, who are in business. The turnaround time of Uganda National Bureau of Standards is 12 months, almost 12 months. From the time you put a product to request for certification, it takes you about a year for them to certify a product. Whereas our counterparts here in Kenya, it takes less than a month to certify a product. Now, it has heavily costed many people who are in business. And it is only Uganda National Bureau of Standards that can give a visa to a product to go beyond the boundaries of Uganda. So I want to implore you and request Madam Speaker that we, through you, that you execute and allow the Committee of Trade to go and make an examination, to examine, assess the gymnastics and integrities of the operations of that entity. Otherwise, we shall always keep putting our products and they are not certified in time, and hence we are losing business. And it is getting money. To certify a single product, you need to pay about 800,000. It collects over 80 billion annually, and its budget is about 40 billion. So, Madam Speaker, I think it is prudent.
Thank you.
Information,
Thank
Madam.
you. Yes.
Thank you very much, Right Honourable Speaker. I want to thank my colleague for raising a matter on the Uganda National Bureau of Standards. Right Honourable Speaker, in this country, we from the fishing communities...
It is not your colleague who raised, I raised.
Okay, following up your for us from the fishing communities in this country are suffering at the hands of Uganda National Bureau of Standards. Why do I say that, Right Honourable Speaker? There are so-called illegal fishing gears, and yet Uganda Bureau of Standards is supposed to be at every one-stop center of the customs in this country to ensure that whatever product is not acceptable on the market of Uganda should not enter the country. The fishermen are now asking if these gears are illegal, where are they being produced in Uganda? If they are produced in Uganda, why is the government of Uganda allowing it on the market of Uganda? And if they are being imported, then why is the government allowing? And we have this agency called Uganda National Bureau of Standards. Right Honourable Speaker, that's why I really want to agree with my colleague that the traders, not only traders are suffering in this country at the hands of the Bureau, but even other communities like the fishing communities. So really, as Parliament, we should pronounce ourselves that these so-called illegal, undersized fishing gears should not be on the Ugandan markets so that our people don't continue to suffer.
There is another information here.
Right Honourable Speaker and colleagues, I think the issue being raised needs to be understood in context. Number one, the Minister of Trade, who is here, needs to tell us why we are still implementing the External Trade Act when we actually entered into the Common Market Protocol. Because the ministry has been licensing those fishing nets you are talking about, it's been the ministry, and the Minister of Trade, Honorable Bahati, is here. He needs to tell us. Strengthening Uganda National Bureau of Standards is the responsibility of the Ministry of Trade. So the ministry should tell us where the challenges are, and then us as Parliament, as a committee responsible, we need to see how we can sufficiently fund Uganda National Bureau of Standards to undertake their mandate. We as Parliament, we have a responsibility, but the larger responsibility lies with the minister in terms of the laws that we are using to license people to bring in nets when they are undersized, and also the conflict between the laws which became obsolete because of the Common Market Protocol, but which the minister continues to invoke.
Honorable Minister, yes, additional information.
Thank you, Madam Speaker. We have had a discussion at the subcommittee of PACOB in charge of private sector competitiveness, where this matter was exhaustively discussed. UNBS, Madam Speaker and colleagues, is underperforming because of one, capacity. They have few people, they cannot perform the task. Secondly, the nature of their funding is a problem. Because when people who want the approval of the standards pay through URA and the money goes to a consolidated fund, the budget they have cannot finance the requirement that is out there. So as Parliament, we need to review this so that we can enable them to perform.
Thank you.
Thank you very much, Madam Speaker. Madam Speaker, the matter you've raised is very important. Whereas Bureau of Standards wants to be supported, but we must also look at support to those who are consuming their services. Importers in this case. Madam Speaker, pre-shipment inspection is mandatory for any imports coming into the country. And for the reason that the National Bureau of Standards does not have the support that Honorable Katesha has talked about, we need to support them. We have importers bringing goods from various countries outside Uganda. But because you don't have agencies representing Bureau of Standards in those countries, they come with their goods here and they are instead penalized because they were not able to have pre-shipment inspection done. So we need to support them both in terms of capacity, in terms of resources, in order to allow trade to flow across board. I thank you very much.
Thank you. Jude.
Madam. Thank you, Right Honourable Speaker. Right Honourable Speaker, the issue of certification is a fundamental issue because not only is it for persons coming with new products, but even existing products. And we've seen cases whereby after a product has been certified for 1 year, 1 year has expired, UNBS requires you not to put the product on the shelf until the certification has been renewed. Yet they take more than 3 months to renew their certification. And that means you cannot even export the product. You cannot even produce additional product for almost 3 months. I'm giving this from a personal experience. Secondly, Right Honourable Speaker, is on the mandate for Uganda National Bureau of Standards. According to the mandate, they said they regulate any item that is of a rubber material, and as a result of that, gloves and also condoms qualify under that, and an item of plastic material, and as a result of that, even syringes. Now, as a result of that, there is dual regulation, because National Drug Authority also has the mandate to regulate medicines and supplies, and they are doing the regulation. So what is happening is that there is pre-import verification testing that is done for the gloves and the condoms by UNBS. Then it comes to NDA, again, tests are done. And there have been cases whereby one entity has passed the items, another entity has failed the items. It is very important that the Attorney General gives guidance and direction on which entity has the mandate to regulate these items. And if there is need to amend the law, then we need to have this amendment, because this is something as a health committee has been raised as a concern to us by National Drug Authority. Thank you.
Thank you, Madam Speaker. Madam Speaker, in line of UNBS, not only traders who are suffering, but even our local farmers, they are being challenged with fake agricultural imports on the market, fake fertilizers, fake seeds. I remember you guided very well that the minister should bring a statement specifically on fake agricultural imports. But as of now, the minister has never come back to handle that matter. So both ministers, for trade and for agriculture, they should pay a statement in that line, because our farmers are making a lot of losses. Thank you.
But it's not only making a lot of losses. When you treat, say you're treating cows with the fake medicines, when they die, people eat. The sickness now moves on to even human beings. So it has that effect, a trickle-down effect. Macho?
Madam Speaker, you are spot on the matter of a National Bureau. It is last year that I brought a matter on floor concerning pre-shipment inspection, and you did direct the Minister of Trade to bring a report on that matter. And up to now, Madam Speaker, the report has not been brought at all. And we still hear there are wrangles concerning ship inspection. And Madam Speaker, in addition to that, truly, the National Bureau needs to be helped a lot, because as we talk now, we have so many men who are having cases of impotent because of a bad liquor on the market, making a lot of women to suffer a lot. Therefore, we should help these people to get enough money as quick as possible so that they have enough staff. Madam Speaker, I think you are... I really
what did you say?
Madam Speaker, I said we are having challenges in this country due to limited staff from the National Bureau. We have men who are impotent, making women to suffer because we don't have enough staff to pre-qualify the liquor on the market. That's why we have alcoholic products with very different names, like tokutoku, like hubatu sosola, like shapuyu. All those names that are named on these liquors have not been protested by the National Bureau of Standards. And therefore, the Minister of Trade should tell us how we can see that this bad liquor on the market that is causing a problem of divorce and gender domestic violence be off from the shelves. Thank you, Madam Speaker. Information.
Thank you. Your order on the whole, yes, finished. Honorable members, by the time somebody says they are impotent men, maybe it's one of them. Afidra.
Thank you, Right Honorable Speaker. On your communication regarding the issue of UNBS, I want to speak as a former board member of UNBS. And first, yes, I was a board member of Uganda National Bureau of Standards appointed by the President. I served for 6 years. And I want to make a submission first by thanking Parliament. 2 years ago, Parliament appropriated resources for UNBS, where they recruited more than 100 staff. This was in the financial year 2022-2023. And here, if we were talking about lack of staffing or inadequate staff at UNBS, Madam Speaker, my opinion is the utilization of the few staff to be able to deliver maximally. We know that government stopped recruitment in many institutions, including UNBS. But that said, what I want to submit more on, and it is very challenging, is pre-shipment inspection. We received a circular by the ED, Uganda National Bureau of Standards, instructing that this service, where the condoms are supposed to be inspected before they are shipped, all the vehicles supposed to be inspected before they are shipped into this country, that service is now being stopped. And that service, therefore, is going to be carried out by the UNBS. And therefore, if this service is going to be carried out by UNBS, what is the staffing quality? What is the preparation of UNBS to be able to undertake this service in country? Aware that we have issues of quality, aware that we have issues of corruption in this country. So my take is UNBS should come out through the Minister of Trade and explain to the country that the quality of vehicles, the quality of different imports that Ugandans consume will not be jeopardized by the fact that it's now being done in country apart from being done from the pre-shipment inspection destinations, whether it be in Dubai or Japan or China. That is my greatest worry, and that's where I want to applaud you through the minister to come up with clarity whether this is the situation now or the service providers will continue to conduct their services of pre-shipment inspection from the different countries. Right Honorable, I beg to submit.
Thank you so much. We will wait to, these are the gallant persons we introduced, the athletes. Please just stand up and wave at, please stand up. Who is Chelang? Chelang? Chesang. Okay, we'll wait when they come. Honorable Minister, before you respond, I met Uganda National Cultural Center this morning, and this goes to Attorney General, and their complaint is that they have a law which is older than Uganda in independence, which was formed in 1959, and because of the changing environment, they want to preserve the heritage of the country, so they are requesting that you bring amendment to their law. And then secondly, I also got information from my clerk where Equal Opportunities Commission and Public Service have written to the clerk that they want a report on how much each member of parliament gets, how much do staffs of parliament get. I think people are forgetting separation of power. The Uganda Parliamentary Commission is a standalone. We do not belong to Equal Opportunities. We are not civil servants for public service to start asking for the salaries of members of parliament. And it is high time, Attorney General, you tell these people that we have our independence. We should not be asked. Honorable Minister, let Lob first say then.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, Uganda National Bureau of Statistics has two major mandatory roles. Oh yes, Uganda National Bureau of Standards has two major mandatory roles, that of inspection and that of market surveillance. But they grapple with the two challenges, Madam Speaker. Even with the recent, the body member mentioned, former, even with that recent recruitment, they are still grappling with the challenge of huge staffing gaps. And I know the minister should be aware of this. I myself at the border, because I'm very common at the border, during a pre-shipment challenge, which the Honorable, together with the Honorable Angura, who were there. And we compared and contrasted the staff between the ones of Kenya and Uganda. Uganda has a skeleton staff of below 5. The other place is almost times 3. So that is a challenge. But the other one is that of corruption. In this particular agency, they have perpetuated a culture of impunity. They take bribes in broad daylight and allow such counterfeits like the one the Honorable Member of Nebi mentioned. Backwatch. Most of these fake goods on the market, this particular National Bureau of Standards cannot conduct country-wide inspection like they are required by law, and that's why they are awash in the country, all the counterfeits. Thank you, Madam Speaker.
Thank you, Minister.
Thank you, Madam Speaker, and thank you, honorable colleagues, for the issues you have raised about UNBS. UNBS has a mandate to ensure the safety of the lives of Ugandans, but also to ensure the standards of the products that we produce in the country so that they can meet international standards and access the markets both domestically and internationally. And as a result of the expansion of our industrial sector, as you recall, Madam Speaker and honorable colleagues, the industrial sector has grown. We are now contributing 27.4% to our national GDP, and manufacturing alone contributing 16.5%. Grown from 85 factories in 1986, and now 9,400 factories. This requires capacity to monitor all these activities and ensure that the products are inspected and the standards are kept. So the length of time that we take should be on an average of 2 months. And we shall get the report, Madam Speaker, and circulate it to all members of Parliament to see how many have applied and how long we have taken to approve, to satisfy. Some of the reasons why they take long is because some companies ask some information and they don't give it in time. And yet we must ensure the safety of these products. So I'm happy that this afternoon there seemed to be a consensus coming out of members of Parliament that UNBS needs to be supported, to be given resources enough to recruit enough people for enforcement, to recruit enough people for certification. On the second point of harmonization of UNBS laws and NDA, we proposed an amendment to the UNDA Act, and we are working together with the Minister of Health. Actually, tomorrow we have a consultative meeting to ensure that we harmonize to see which products are handled by UNBS, which products are going to be handled by NDA. And the Attorney General is providing guidance in this matter. On why we are still applying the External Trade Act vis-a-vis the new act that was enacted, as far as we understand, and the Attorney General will give guidance, the External Trade Act has never been repealed, and therefore it is still a law that is applied in Uganda. But the Attorney General can give more information. So, Madam Speaker, we will be ready.
Thank you, Minister, for giving. Well, Madam Speaker, I'm just seeking for some more clarification from the Minister. What do you lose by also benefiting from this rationalization bonanza that you take UNBS back to the ministry? You also benefit from what has been happening. Since it is incompetent, you create a desk there.
We are not saying it is
incompetent. You appoint a EPDF soldier to manage it, and we move on.
We are not saying it is incompetent. Honorable members, we are not saying it is incompetent. We are saying there are delays. And those delays, the problem is because there is no money. It is you who appropriates the money.
Madam Speaker, Madam Speaker.
There is a procedure matter.
Thank you.
Thank you so much.
There is a procedure matter.
Okay, Madam Speaker.
Thank you so much, Right Honourable Speaker, for giving me this opportunity. My procedural matter is in relation to what the Minister just said, that the House has built consensus on the financial constraint. And as he made emphasis on this, won't it be right for us to get to know exactly the shortage in terms of finances that this entity has and their plans, so that we get a way of fixing. Therefore, without knowing how much, are we proceeding rightly?
We are proceeding well because we have a sectoral committee responsible for it and to look at all those issues that are being raised, and it will report to this house. Since we are going for BFP, so the sectoral committee is looking at it. Honorable members, when you look at, I'm still on the salaries of members of parliament. When you look at Article 32(3), there shall be a commission called the Equal Opportunities Commission, whose composition and functions shall be determined by an act of parliament. The Equal Opportunities Commission shall be established within 1 year after the coming into force of the Constitution as amended in 1995. Can I have some attention? Parliament shall make laws for the purpose of giving full effect to this article. When you look at Article 85, emoluments of members of parliament, that is self-explanatory. Attorney General, is it correct for equal opportunities to go beyond its powers and come and start investigating on what they are not supposed to?
Thank you, Right Honorable Speaker. Right Honorable Speaker and Honorable colleagues, the mandate of Equal Opportunities Commission is restricted to persons who are marginalized on the basis of gender, age, disability, and other reasons created by history, tradition, or custom. Now, we are having a challenge because, when I look at the petition they have sent to you, I'll be sure to render advice on the same. I think that would be an extension, because then they are going to start becoming the High Court and the Court of Appeal. So
the
I think,
Supreme Court. And
they need to maintain the level where they are supposed to be. And we shall advise them, and we have advised them consistently on this. It's a line that needs to be drawn carefully, so that you know, because this equal opportunities is supposed to help with affirmative action. Yes. So we will render the advice, Right Honorable Speaker.
Thank you.
Yes.
Thank you.
And then the issue of the...
Thank you, Right Honorable Speaker and the Attorney General, for giving way. Vulnerabilities sometimes are established by comparison. If you want to know that people are marginalized, you look at those that are not. So if you stop the equal opportunities to compare other people with the MPs and Parliament, where are you sending them? To compare them with Kenya and Rwanda? Because within the same environment, comparison is what will show you the vulnerabilities in terms of... so the clarification I'm seeking is whether you are now stopping them from making that comparison.
Thank you very much, honorable colleagues. In a nutshell, yes. Because I am telling them that they can only compare where you say that men shall have 10% and women shall have 5%. That's the marginalization they deal with.
You first respond to.
Yeah, so they are not entitled to compare everything and anything. They are supposed to compare marginalization because of gender, sex, disability, and other matters created by history. For example, when you have the Batwa being marginalized against other people in Uganda. So if we are not careful, we may now start saying that we now need to have equal opportunities because everyone must drive the same car, everyone must be the same height, everyone must be, so that's not the equal opportunities that was anticipated here. It was supposed to ensure that we do not write laws or implement policies which say that one gender shall be given better treatment as opposed to another gender. So that's what marginalization was about. So in a nutshell, I'm saying yes, they cannot just compare anything.
Thank you, Attorney General. The equal opportunities should act within their mandate. They should not go ultra-vires. Let them act within what they are supposed to do. Next item.
Bill second reading, the Technical and Vocational Education and Training Bill.
Thank you very much.
Yes.
Madam Speaker, last week, we requested and you directed government to come here and answer issues of sovereignty. How did they access Kenya to abduct Dr. Kizza Besigye? The reason they didn't answer that time was because you said, Madam Speaker, that the minister responsible was away and he will be here on Tuesday. But also related to the Madam Speaker, issues of sovereignty, we need government to allay our fears about reports that an American surveillance aircraft has violated our sovereignty on 3 occasions. For us, we can violate the one of Kenya and then complain when America is violating ours. But we need you to allay our fears. Because the background to this is that you had the CDF giving American ambassador 48 hours to apologize to his father. Subsequently, you have an American surveillance aircraft violating our airspace. So can government lay our fear that we are not at war? I don't know what's wrong with the LODUs. This is a very serious matter.
Order.
He's on procedure.
Thank you so much, Madam Speaker. He has given way, so I thank him for having listened to me. Madam Speaker, the matter of Uganda picking Dr. Besigye from Kenya is still under investigation.
Honorable members, I am not going to allow any debate on that matter.
Thank you so much, Madam Speaker.
I said the report should come from Internal Affairs and the Minister of Foreign Affairs, and I don't see them here. We are not going to discuss on ministers who are not here.
That's why I was putting him to order, and I was wondering whether he's in order to compare it with American.
Madam Speaker, I told you he's my neighbor. When he was an LOD, you used to behave like exactly that. So
he's a honorable member of parliament.
I am.
He's a honorable member of parliament.
He's a honorable member of parliament, but he has a history.
No.
He has a history.
As of now, he's a member of parliament.
I agree, Madam Speaker. If it offends him to speak about his history, I am very sorry.
Yes.
Madam Speaker, I want to go to the subject matter that you directed government to come and explain.
There is an order.
Madam Speaker, first of all, my colleague and a very close friend is imputing that we have one of us who is an LDU. Is he in order to begin imagining that a colleague who is here, who could even be given opportunity to substantiate to himself whether he's an LDU or no, is he in order, Madam Speaker, for him to impute that? Is he in order?
No, he withdrew and apologized. He withdrew.
So, Madam Speaker, Can I reiterate the serious issues that you asked Foreign Affairs and Internal Affairs?
I have asked them, and I'm waiting for a response. And as I told you, that the ministers were not available because they had asked for permission from me to be away. And they are going to be back. By Thursday, we shall have a report.
Thank you very much, Madam Speaker. As I said, can they also lay our fears that we are not at war with America?
We don't know those ones. Honorable members, the team in the gallery is a national swimming team. Please stand up, the national swimming team. They have just won. They were the winners of Africa in the champions in Bujumbura, Burundi. You're most welcome. They are here. They came along with their trophy, their medals. Where is the trophy? Show us. They came along with their trophy that is going to be led by one of their young, their age mate, one of the youth. And we want to thank you so much and congratulate you. Please have a seat. Join me in thanking them. And
thank you very much.
We'll have a motion recognizing you at an ample time. We may not have the motion today.
Okay.
All you are supposed to do is to show us the
thank you very much, Right Honourable Speaker. I also join you in congratulating this very formidable team. This is a team of national swimmers, and they've won the Africa Aquatics Zone 3 Championships in Bujumbura. As you've rightfully acknowledged, these are all young people. And certainly, young people who make our country proud ought to be saluted. And I thank you, Right Honourable Speaker.
Thank you.
For accepting that a motion at an appropriate time should be brought to this House to celebrate and congratulate our young people.
Thank you.
So before us, this is the main trophy that they won for our country in the Africa Championships. And Right Honourable Speaker, these are all individual trophies that some of them won for our country as well.
Thank you. Thank you.
I also want to just acknowledge, Right Honourable, that a majority of these individual trophies are our young girls. So it means that as opposed to the old notion that perhaps girls cannot do as much as the boys, these young girls have actually made us very proud.
It has never been. Girls are girls. Women are women. Women can do everything.
There is a song, Right Honourable Speaker, that who runs the world?
The women.
And the response is girls. So congratulations to Team Uganda. And Right Honourable Speaker, you will allocate time and will do the needful.
Thank you so much. Minister of Sports.
Well, Madam Speaker and colleagues, first of all, let me begin by congratulating the Uganda Swimming Federation and the entire team before us here for giving us position number 1 in Zone 3 competition, which just concluded in Bujumbura. Let's clap for them, honorable colleagues. Madam Speaker, like I've always said that, first of all, the support from government and the support from this August House is what is giving our country to begin to outshine our competitors in various sports disciplines. For swimming, colleagues, swimming is a very expensive sport because as far as we are concerned, the investment part has been done by the private sector, and as far as government is concerned, I want to confirm Akibwa Stadium will have a semi-Olympic swimming pool. Hoima City Stadium will have a semi-Olympic swimming pool. Nambole National Stadium here, we are working with the International Olympic Committee. We'll have a standard Olympic swimming pool Once we finish up with our programs of coming up with state-of-the-art indoor arena in Lugogo, we'll have a swimming pool. Currently, we are under constructing a semi-Olympic swimming pool in Teso College, Aloet. So as far as government investment in swimming is concerned, we are committed to ensuring that this infrastructure is available for our children to compete internationally. I also want to congratulate and thank the team which participated in the International Olympic competition which took place in Paris. Madam Speaker, and swimmers here, I congratulate you and welcome back home. Thank you so much.
Thank you, Honorable Minister. We appreciate the construction of swimming pools wherever.
Like earlier on said, the investment has been partially by the private sector, and one of the private sectors before us here is the Speaker. I want to confirm she has constructed a swimming pool in Bukedia, the first of its kind, which we used during the Federation of the East African Secondary Schools competitions here in Uganda. Madam Speaker, I congratulate you for leading. So you and others have made it possible. That's why now I'm saying as government, we are now beginning to invest.
And Committee of Education,
thank you.
I want you to interest yourself in the cost of those swimming pools, because I know the cost. I know the cost. I want you to interest yourself. Next item, Shadow.
Thank you very much, Right Honorable Speaker. First of all, I want to thank this Parliament, led by you, the Speaker, for giving sports time. When we came here, the sports budget was very low. But with your intervention, Madam Speaker, sports has benefited a lot. And you see the number we are jubilating now. If it wasn't you, I don't think our team would have qualified. So I want to thank you. So with the swimming, I want to thank the Federation, Uganda Swimming Federation, for the work, the good work done for mobilizing these children and participating. We know the government still has an idea of constructing swimming pools. That's the thing we have been facing, the hard way we have been facing with the facilities of sports in Uganda. I call upon the government to put more focus on the facilities and more budget in the federations. Madam Speaker, there is a sport, dance sport, which has to go in the Olympics. As we speak now, they have no budget. And it's the same thing that is facing with other federations. So I call upon the Minister of Finance and the Education Ministry to add more money to the Sports Federation for the good of our people. Thank you very much.
Thank you. Honorable Linus. Honorable Linus.
Well, Speaker, I think we should applaud the swimming team, because as I speak here, my late father, Mr. Paminga, is the sole gentleman who introduced competitive swimming in Uganda. He introduced nine Olympic sports, and the president of swimming competition, Mr. Mwase, can testify. So I would like to thank them for a good job done. And as Parliament, through the Speaker, I believe we shall always support you and the Ministry of Sports as well. Thank you, Right Honourable. Thank you.
Thank you. Next item. Honourable members, with the bill, with the motions, bear with me. I want to start with the bill, then I come to your motions.
Item 6 on the order paper. Bill second reading. The Technical and Vocational Education and Training Bill 2024.
Thank you very much, Right Honourable Speaker. Right Honourable Speaker and my dear colleagues, I also first of all, I want to join my colleague, Minister, to congratulate and thank our swimmers for making us proud. Thank you very much for making us proud.
Honourable members, before the Minister comes in, you recall that on 26th November, 2024, the Minister of Education and Sports tabled the Technical and Vocational Educational and Training Bill 2024. The bill was referred to the Committee of Education and Sports for consideration, and we are aware that the report is now ready and the Minister is ready to report. And as per Rule 131 of the Rules of Procedure, can the Minister move a motion to the effect?
Thank you very much, Madam Speaker, and thank you for that clarification. Right Honourable Speaker, I beg to move that the Technical and Vocational Education and Training Bill 2024 be read for second time. I move.
Is the motion seconded? Seconded by Honorable Guang, by Honorable Kubex, Honorable Edie, Honorable Dakas, Afidra, Patience, Mitoma, Okeot, by the whole side, including Mbwa, Aru, Nakawa, Jinja, Honorable Zijan, DP, Honorable Chut, Honorable Kelly, Honorable Apea, Honorable Lamwaka, Honorable Alanyo, Honorable Nekesa, Honorable Josephat, Honorable Abe, Honorable Linos, Honorable Avur. I like that you refuse to sit. Okay, would you speak, give us the objectives of your bill?
Thank you very much, Right Honourable Speaker. Right Honourable Speaker and dear colleagues, the Technical Vocation Education and Training Bill 2024 was presented, as the Speaker says, in August, in this August House on Tuesday, 26th November 2024, for the first reading and consideration by Parliament. This bill seeks to establish an employer-led TVET system that is functional, effective, efficient, to meet the demands and priorities of the labor market. The bill proposes harmonization, synchronization, and a merger of the function of various TVET assessment bodies into one homogeneous function to reduce costs and easier coordination, in line with the Cabinet's directive on rationalization of government agencies, commissions, authorities, and public expenditure (APEX). Specifically, it proposes the transition and the merger of A, Uganda Business and Technical Examinations Board, UBTEB, and the Directorate of Industrial Training into the Uganda Vocational and Technical Assessment Board. B, Uganda Allied Health Examinations Board and Uganda Nurses and Midwifery Examinations Board into the Health Professionals Assessment Board. I submit, Madam Speaker.
Thank you, Honourable Minister. Chair, can you now present the report?
Thank you very much, Right Honourable Speaker. I would like to present a report of the Committee on Education and Sports on the Technical and Vocational Education and Training Bill 2024. Right Honourable Speaker, these are the minutes of the proceedings, and I laid them on the table. Right Honourable Speaker, the introduction. On Tuesday, 26th November 2024, the fourth session of the first sitting of the second meeting of Parliament, the Technical and Vocational Education and Training TVET Bill
was read for the first time by the Minister of Education and Sports, Dr. Chrysostom Muyingo, and the certificate of financial implication was laid on the table as required by Rule 118 of the Rules of Procedure of Parliament, and the Speaker referred the bill to the Committee on Education and Sports. The background of the bill: the current law, which regulates technical and vocational training in Uganda, is the Business, Technical, Vocational Education and Training Act, CAP 244, and the Act provides for the promotion and coordination of business, technical, vocational education, and training. And it provides for the principles governing TVET. It also establishes the institutional framework for the promotion and coordination of TVET, and it establishes the Uganda Vocational Qualifications Framework and provides for the financing of TVET. The Minister of Education and Sports informed the committee that law was never fully operationalized due to a number of challenges, namely overlapping mandates with other institutions. TVET delivery remains inadequately funded, fragmented, and uncoordinated across the various sectors, and the provisions of the TVET Act are inadequate. So the committee was informed that the bill seeks to operationalize the TVET policy of 2019 by providing for the regulation and promotion of TVET, establishment of TVET Council and sector skills expert committees, providing for the establishment and regulation of TVET providers and management and governance structures of TVET providers, registration and licensing of TVET trainers, development of the TVET qualification framework, development of the TVET curricula, establishment of the TVET assessment boards, and consolidate laws regulating TVET providers under this Act. So the bill will thus cause a repeal of the Business and Technical Vocational Education and Training Act, CAP 244, and the Management Training and Advisory Center Act 256, CAP 256, the Hotel and Tourism Training Institute Act, CAP 219, Uganda Wildlife Research and Training Institute, CAP 261. The object of the bill as follows. One is to establish an institutional framework for the promotion, coordination, regulation, and delivery of the TVET system. B, to provide for the implementation of policies, decisions, and directives issued by the minister or any other person authorized by the minister. C is to develop TVET qualifications framework. D is to define the scope of TVET course or program and the role of the different stakeholders in the process of skills training. E, to regulate and quality assure TVET providers. F is to regulate TVET trainers. And G, to provide for the regulation and licensing of craftsmen, technician, and technologist. H is to provide for the establishment of TVET Assessment Board, and I, to provide for the establishment and management of Skills Development Fund. Right Honorable Speaker, methodology. 3.1 is we used desk research. The committee reviewed various legislations, and these included the Constitution of the Republic of Uganda, 1995, the TVET Act, CAP 244, the National Curriculum Development Center Act, CAP 254, and the Universities and Other Tertiary Institutions Act, CAP 262. The committee reviewed the TVET Policy 2019. Meetings. The committee invited 8 stakeholders, held meetings, and received memoranda from them. One of them was the Minister of Education and Sports. 2, the Uganda Business and Technical Examinations Board, UBTEB. 3, the Uganda Manufacturers Association, UMA. 4, the Uganda Nurses and Midwives Examinations Board, UNBS. E, the Uganda Allied Health Examinations Board, UAHEB. F, the Directorate of Industrial Training, DIT. G, the Federation of Uganda Employers, FAWE. And H, the Management Training and Advisory Center, MTAC. The findings. In the objectives of the Act, Clause 3 of the bill provides for objectives of the Act as spelled out earlier in this report. Committee observations, Right Honourable Speaker. The committee observes that the aspect of licensing of TVET trainers was not provided for under Clause 3F of the bill. Recommendation. The committee recommends that Clause 3F should provide for the aspect of licensing of TVET trainers. 4.2, the Technical and Vocational Training TVET Council. Clause 4 of the bill establishes the Technical and Vocational Training TVET Council, and the composition of the council is provided for under Clause 8. The bill proposes that council shall be comprised of a chairperson and 6 members, and that 66% of the council membership shall be employers. The Uganda Manufacturers Association, UMA, in its interaction with the committee, proposed that the bill should specify that one of the employers proposed in the council membership should be a manufacturer, since they are the biggest consumers of TVET services. Committee observations. The committee perused paragraph 7.2.1 of the TVET policy and found that one of the policy objectives of the formation of a TVET council as a regulatory body representing the demand side of the TVET policy, with the 2/3, that is 66% of the council members being employers from the industry. The policy further states that the institutional mandate for employers through the TVET council will be to regulate TVET through establishment of standards, qualifications, registration, and accreditation systems for institutions, stock providers, programs, and trainers. And the committee observes that the use of 2/3 representation is more conventional in legislation as opposed to the percentage. Recommendation. The committee therefore recommends that A, one of the 6 members of the council shall be a manufacturer, and B, instead of the use of a percentage, the membership be specified as 2/3. 4.3, development of a TVET qualification framework. The bill under Clause 28 provides for the development of a TVET qualifications framework. And Clause 28.5 provides that the framework shall be reviewed at least after 3 years. The Federation of Uganda Employers made a proposal to the committee to change the number of years for review of the TVET qualifications framework from 3 years to 5 years to minimize costs. Committee observations. The committee agrees with the Federation of Uganda Employers that the development of a TVET qualifications framework every 3 years will be costly or a costly venture for the council. Recommendation. The committee recommends that the TVET qualifications framework be reviewed after 5 years. 4.4, delivery of technical and vocational education and training, and the categorization of formal TVET providers. Clause 29 and 30 of the bill provide for the delivery of TVET and the categorization of the formal TVET providers respectively. And Clause 29 introduces the aspect that TVET may be delivered formally or informally. And the clause also provides for a punishment for a person who contravenes Section 30, this section. And Clause 30 of the bill provides for the different TVET providers who can provide formal training and specifies the field of TVET. Now, the committee interacted with the MTAC, which indicated that the aspect of management is not covered under Clause 30 of the bill. Committee observations. The committee observes that the use of different terminologies of informal, formal delivery, formal TVET providers creates confusion, since these terminologies are not defined in Clause 2 of the bill. So the committee further observes that there is need to differentiate the punishment in Clause 29 for an individual from that of a body corporate. And the committee agrees with MTAC that some of the fields of TVET were left out in the bill, such as management. So the committee foresees a risk in not allowing the minister to prescribe other fields of TVET as may be necessary under this clause. Recommendation. The committee recommends that A, the terminologies formal training or informal training should be used in the bill instead of introducing new terminologies, since they are clearly defined under Clause 2 of the bill. B, the punishment of an individual be distinguished from that of a body corporate. And C, Clause 30 be amended to provide for management as one of the fields of the TVET, and in order to allow the minister to prescribe other fields of TVET as may be necessary. 4.5, conflicting roles with National Council for Higher Education. Clause 36, Section 6 of the bill requires a university, other degree awarding institution, or tertiary institution established under the Universities and Other Tertiary Institutions Act to apply to the Council to be accredited to offer a TVET program or course in accordance with the provisions of this Act. And Clause 31(4) provides that a university, other degree awarding institutions, or tertiary institution established under the Universities and Other Tertiary Institutions Act shall not offer a TVET program leading to an award of a national higher diploma, degree, or postgraduate. And Clause 32(2) provides that a person shall not establish or operate as a TVET provider at a level of national polytechnic or national technical university unless it is established as a public TVET provider by the minister. The Minister of Education and Sports informed the committee that the intention of the bill is to have a one body that addresses all issues related to TVET, and this is the practice in other countries. They further stated that that in order to ensure that the bill does not conflict with existing laws, it provides under Clause 118 this application of certain enactments, that the following laws shall not apply to the TVET provider unless otherwise expressly provided for under this Act. Among these acts of this application include the Universities and Other Tertiary Institutions Act, the National Curriculum Development Center Act, the Education Pre-Primary, Primary and Post-Primary Act, and the Uganda Nurses Examinations Board Act. So the ministry also indicated to the committee that the university, other tertiary awarding, other degree awarding institution or tertiary institution established under the Universities and Other Tertiary Institutions Act are academic oriented and not practical oriented. So this is the reason why those entities under this Act, or under this law, or this law will be authorized to teach trainers at technical college level and below and award only national technical diploma and below. On the aspect of Clause 32(2), the ministry informed the committee that the National Polytechnic and National Technical University level are a preserve of the public sector and not the private sector, because TVET is a costly enterprise characterized by the acquisition of heavy equipment, among other requirements, which a private person cannot afford, and that government will establish these institutions gradually in order to meet the needs of higher education for TVET trainees. Committee observation. The committee observes that Clause 35 requires the entities covered under the Universities and Other Tertiary Institutions Act to be accredited for TVET programs under this Act, that this role is carried out by the National Council for Higher Education in the current regime. The committee notes that the word may was used instead of shall, and yet, from the ministry's explanation, it is the intention of the bill to have one body to regulate TVET. Committee recommendation. The committee recommends that Clause 35 be amended to make it mandatory for any university, other degree awarding institutions or tertiary institutions established under the Universities and Other Tertiary Institutions Act to be accredited under this law. 4.6, accreditation of TVET providers. Clause 41 of the bill provides for grant or refusal of accreditation of TVET providers. And the clause provides that the minister shall prescribe the time within which the council can consider an application and grant or refuse to accredit a TVET provider. Clause 41.3 provides that where the council rejects or refuses an application for accreditation, the council shall give reasons and notify the applicant. The clause, however, leaves it to the minister to prescribe the time in the regulations. Committee observations. The committee observes that the time within which the council can consider an application and grant or refuse to accredit a TVET provider, or the time within which the council shall notify applicants, should be provided for in the parent law. Recommendation. The committee recommends that Clause 41 be amended to provide for 6 months to consider an application by the council and a notification of an applicant within 1 month. 4.7, Governing Council of TVET Providers and Board of Governors of TVET Skills Development Center or Vocational Training Institute. The committee notes that Clause 51 of the bill provides for the Governing Council for TVET providers at the level of a technical college, national polytechnic, or national technical university. And Clause 58 of the bill provides for the board of governance of a TVET provider at the level of Skills Development Center or Vocational Training Institute. Committee observations. The committee observes that since Clause 5G of the bill provides that one of the functions of the TVET Council shall be to register, license, inspect, and accredit TVET providers, the tenure of the members of council should tally with the tenure of the governing council or board of governors of the different TVET providers. And the committee further observes that Clause 51.4 and 58.4 makes it optional for a member of the governing council or board of governors to be paid allowances. This is not fair for members who spare their time to ensure the smooth running of the TVET institutions. The committee also notes that there is a problem with the transition of governing council or board of governors. Once their time lapses, as such, the law should implore the incumbent bodies to ensure smooth transition. So the committee also observes that the women representation on the two bodies is tied to only one person and not across the board. Recommendation. The committee recommends that clause 51 and 58 of the bill be amended to A. Provide for tenure of the governing council or board of governors as 4 years. B. To make it mandatory for members of the governing council or a board of the governing or board of governors of TVET colleges, National Polytechnic or National Technical University to be paid allowances. C. Provide for women representation to cut across any on the council and not only one person as it was proposed in the bill. And D. To ensure a smooth transition between the incumbent governing council and the incoming governing council or board of governors. 4.8. Registration and licensing of TVET trainer. Clause 63 of the bill provides for the registration of TVET trainers, and Clause 69 provides for the TVET trainer license. Clause 74 of the bill, however, exempts certain categories of persons from registration or licensing under the bill. Committee observations. The committee observes that the persons exempted from licensing or registration should be provided for under Clause 63 and 69 before being introduced under Clause 74 of the bill. And the committee further observes that the persons exempted should have their register under Clause 116. Recommendation. The committee recommends that A. Clause 63 and 69 of the bill should provide for persons exempted from registration or licensing as prescribed under Section 74, and B. Clause 116 be amended to provide for a register for persons exempted from registration or licensing as prescribed under Section 74. 4.9. Composition of Uganda Health Professionals Assessment Board. Clause 81.3 of the bill provides for the composition of the Health Professionals Assessment Board, and the committee interacted with the UNBS, which proposed that the board be comprised of 2 persons representing heads of TVET providers, offering health-related programs or courses, and 3 other persons, employers, a person representing employers within public health sector, a person representing employers under the faith-based medical bureaus, and a person representing employers from private hospitals. Committee observations. The committee observes that the specification of the different employers in the health sector is critical as proposed by UNBS, as this will ensure a fair representation.
Honorable members, I think we have guests. Just a minute. In the VIP gallery, we have a delegation from Parliament of Ghana. We have Mrs. Ifia Tenge. She's a director, Procurement Engagement Division. You're most welcome. We have Miss Margaret Donko. You're most welcome. She's a Deputy Director of Public Engagement Division. We have Dr. Lawrence Ashia. You're most welcome. He's the Deputy Director, Media Relations Division. Then we have Mr. Kayora Abdu. You're most welcome. Senior Public Affairs Officer. We have Mr. Sulaiman Sadat. Welcome. Senior Public Affairs Officer. And then we have Miss Ruby, Assistant Public Affairs Officer. You're most welcome. They are here to witness our proceedings. Thank you so much for coming all the way from Ghana, and our regards to the people of Ghana. Yes, continue.
Thank you very much. Honorable Speaker, I was on the committee observations. The committee observes that the specification of the different employers in the health sector is critical as proposed by UNIMEB, as this will ensure a fair representation of different employers. And the committee also observes that there is need to ensure that the TVET providers on this board offer health-related programs or courses. Recommendation. The committee recommends that Clause 81 be amended to A, specify that TVET providers on the board should be those offering health-related programs or courses. And B, specify the different employers within the health sector who shall form the board. 4.10, tenure of members of the TVET Assessment Board. And Clause 83 of the bill provides for the tenure of office of the members of the TVET Assessment Board as 3 years. Committee observation. The committee observes that since the TVET Board will be working closely with the TVET Council in the execution of its functions, the tenure should tally with the tenure of the TVET Council. And recommendation. The committee recommends that Clause 83 of the bill be amended to provide for the tenure of members of the TVET Assessment Board as 4 years. 4.11, Deputy Executive Secretary of the TVET Assessment Board. Clause 92 of the bill provides for the Deputy Executive Secretary of the TVET Assessment Board, and the clause provides for 2 deputies, one of the TVET Assessment and another for TVET Development and Management of the Curricula. In its interaction with the committee, UNIMEB proposed to the committee that the position for 2 deputies be adjusted to Deputy Executive Secretary responsible for nursing and midwifery and another responsible for allied health professionals. Committee observations. The committee observes that since the Uganda Health Professionals Board is merging the 2 bodies, the Uganda Allied Health Examinations Board and the Uganda Nurses and Midwifery Examinations Board, specifying the 2 deputies is necessary. The committee further observes that the Deputy Executive Secretary of TVET, Development and Management of Curricula under the Uganda Vocational and Technical Assessment Board should be added as the role of finance and administration to ensure that the function of the finance and administration is effectively handled. Recommendation. Clause 92 of the bill be amended to specify the 2 executive secretaries, deputy executive secretaries of the Uganda Health Professionals Board, and add the role of finance and administration to the deputy executive director in charge of TVET development and management of curricula. 4.12 is transitional provisions in the bill. Clause 126 of the bill provides for transition applicable to the TVET Assessment Board. Clause 126.5 of the bill provides that the staff in employment of the Uganda Allied Health Examinations Board and the Uganda Nurses and Midwifery Examinations Board in existence immediately before the commencement of this act, other than the board members, shall be merged and continue in the employment of the Health Professionals Assessment Board as the minister may determine and subject to the availability of vacancies. Clause 128.2 of the bill provides that the Uganda Vocational and Technical Assessment Board may, on the effective date of its operations, accept into its employment a person who, immediately before the commencement of this act, was an employee of the Directorate of Industrial Training on permanent and pensionable terms, and who was given an option to serve by the board and be opted to serve as an employee of the board subject to the availability of vacancies. Committee observations. The committee observes that Clause 126.5 leaves the transition of the staff of the 2 bodies to the determination of the minister and subject to availability of positions. This will render some staff unemployed and is thus unfair And the committee further observes that the provision in clause 128.2 requires the board to give a staff member the option to serve, which is also unfair. Recommendation. The committee recommends that clause 126 be amended to provide that staff in employment of the Uganda Health Examinations Board and the Uganda Nurses and Midwifery Examinations Boards should continue in employment in the Uganda Health Professionals Assessment Board. And B, clause 128 be amended to provide that the employee of the Directorate of Industrial Training is the one to give an option on where he or she wants to serve on the board or not. 4.13, Management Training and Advisory Center, MTAC. Clause 121 of the bill repeals the Management Training and Advisory Center Act, CAP 253. The committee interacted with and received written recommendations or memoranda from the Management Training and Advisory Center, MTAC, who submitted that the bill sought to repeal a non-existent law, as the MTAC law was repealed by the Universities and Other Tertiary Institutions Act of 2001. MTAC attached a legal opinion to this written submission dated 19th September 2014 from the Solicitor General that stated that the MTAC law was repealed by the Universities and Other Tertiary Institutions Act 2001. The legal opinion further stated that the Universities and Other Tertiary Institutions Act, Register of Public and Private Tertiary Institutions, Legal Notes number 14 of 2008, lists Management Training and Advisory Center as a public tertiary institution under Part B. The Ministry of Education and Sports stated that following the government policy of rationalization of government agencies, commissions, authorities, and public expenditure, and Cabinet Memoranda CT 2018-128, it was decided that MTAC would be merged with Nakawa Vocational Training Institute. And furthermore, the Ministry of Education and Sports stated that prior meetings were held with MTAC on the bill and were therefore informed about the merger with the Nakawa National Training Institute and the repeal of the MTAC law. In a meeting with the committee, MTAC indicated that the dissolution of the MTAC has far-reaching implications as argued below. One, the dissolution of MTAC will undermine the execution of the projects that informed the establishment of MTAC. B, dissolution of MTAC will significantly undermine the implementation of the micro, small, and medium enterprises policy. C, dissolution of MTAC will erode the relevance of MTAC in the region. D, dissolution of MTAC will suffocate the growth of MTAC business incubators already established in Ntungamo and in Mbale. E, the dissolution of MTAC will significantly undermine the implementation of the National Development Plan, the Uganda Vision 2040, and the Africa Agenda 2063. Committee observations. The committee observes that MTAC law was not repealed by the Universities and Other Tertiary Institutions Act 2001 as is and is still in force. The committee observes that the matter of rationalization of MTAC was approved by Cabinet under Cabinet Memoranda CT 2018-128. Recommendation. The committee recommendations, the provision of the bill in regard to Management and Advisory Center, MTAC, should be maintained in the bill. Conclusion. The committee understands the pertinent need to regularize and promote the TVET sector, and the committee's interaction with the various stakeholders depicts their readiness of rationalization, which is necessary to make the TVET sector better, and the committee recommends that the Parliament adopts the committee report and passes the bill subject to the proposed amendments. I beg to submit, Madam Speaker.
Thank you. Thank you so much, Chair. Honourable members, you've heard the report from the Chair. The floor is open for limited debate. Yes, procedure.
Thank you, Right Honourable Speaker. Right Honourable Speaker, this is a Parliament of Records. And we have a challenge now. Our clerks that process these reports, some of these good reports, with the few changes that have come, they now have a location somewhere here. They cannot increase the volume of the TV because the moment it's increased, it brings the echo. So, and they can't follow properly. Wouldn't it be procedure right through your office, Right Honourable Speaker, so that the Commission now plans for them for a fully-fledged secretariat so that they are placed there, but with an equipment that can enable them to follow and really capture the records as they have been doing, Right Honourable.
Thank you. The records are captured on the Hansard. They do not have the Hansards with them. This, what is on that, on this microphone and that one and whichever is what is captured on the Hansard. And if it is not captured, we shall still give them the report. I know you're missing those girls here, but yes.
Thank you, Madam Speaker. I'm seeking clarification actually from the Honourable Minister and the Chair of the committee. Yes, I understand we are rationalizing all these councils, but then we have National Council of Higher Education, the Teachers' Bill that we were to debate, though we have not debated, is also creating a council. Now we are also creating a council with a board and a committee.
I don't want you to mix two bills, these two bills.
Okay.
Leave the Teachers' Bill alone.
Okay, let me look
That's
at it.
why we are not handling it. Let's discuss about this TVET.
Okay, thank you, Madam Speaker. Now, my clarification is, can't we have one secretariat to handle the National Council of Higher Education and then TVET Council, instead of having an executive director for this, and then we also have an executive director for the other one that is already existing, and others that they maintain to create. And yet we have been saying we should rationalize. When we were rationalizing the agencies under the agricultural sector, we said we should have one entity to regulate all of them. But now we are having 3 entities to actually deal with one sector. So I'm seeking clarification from the Honourable Minister and the Chair of the committee.
Honourable Minister, there needs a clarification.
Thank you very much, Right Honourable. Thank you very much, Right Honourable Speaker. Speaker, when you look at all these commissions, all these agencies, they have completely different functions, and they serve a completely different service. So putting all of them together is going to create us more problems. I submit.
Just like when we rationalized the cotton, all those in agriculture, each of them had a directory. So that's what the minister is saying. Yes, Kazo?
Thank you, Right Honourable Speaker. Right Honourable Speaker, while I listened and heard from the Minister on the issues of performing different roles, in the spirit of rationalization and centralizing power, because this argument came about, Right Honourable Speaker, when we were doing rationalization, that the institutions should be controlled in one place and have small officers who would be deployed. So to avoid also the duplication and overlapping roles and ambiguity in command, I think as we make this law and the subsequent laws, it would make sense that such institutions that share, because they all share what they are doing, apart from that this is maybe primary, secondary,
tertiary, nurses. It would make sense that we have one accounting officer in that perspective, and the rest either principals but reporting to one accounting officer. Right Honorable Speaker.
Yes, John.
Right. Oh,
okay.
Right Honorable Speaker, we may want to get some help in understanding which of these entities you're talking about merging. Because when we say we want all of them together, if you help us and tell us this council should be merged, it may be easier for us to explain why they are separate. But when we don't know what we are talking about merging, it's a bit difficult.
Yes, John.
Thank you, Madam Speaker. I want to give information to my colleagues. Honorable Kimosho, through the Speaker. I want to give information that if you look at the intent of this bill, it's trying to address the challenges that we have been facing in the world of work, and especially with TVET providers and TVET skills development. Now, the TVET delivery has been fragmented. And if you look at the functions of the National Council for Higher Education, will definitely be very different from the functions of the TVET Council that is going to play. So, putting those things together, it is going to create a very, very big challenge in management, development, and application of the skills that we need to get from the trainees.
Jacob.
Yeah, thank you, Madam Speaker. Just to supplement to a colleague, the other aspect of it is that the two should be different just because the National Curriculum Development Center setup has technocrats who have a different orientation from the artisan skills. And the way the National Curriculum Development Center is more of academic than these skills that we are trying to bring up from our population down there. And so because of the difference in the skills, that's why the committee is saying, let this be different, since the other one is more of academic, and then this can be modeled and nurtured in their own way. Thank you.
Dr. Boka.
Yeah, thank you so much, Madam Speaker. I want to thank the chair and the members of the committee for the report. I rise to support the report, but with some observations and areas for clarification. Area number one is in the TVET qualifications framework vis-a-vis a curriculum. Do the two mean the same or they are different things? Two is there's a mention of formal and informal TVET training. There are a number of entities, including civil society organizations, that are involved in training of young people in vocational skills and technical skills. What will be the eligibility criteria for the informal training institutes? And last is in the area of certification, and in the certification within the context of the sub-regional presidential youth skilling centers that have been set up courtesy of the president across the country, where there is no minimum academic requirement for entry. When it comes to certification of the skills, I would like the Minister of Education to guide the nation on how are these going to be certified to meet the basic standards and minimum requirements that makes them eligible to be certified. Thank you.
Thank you. Max? Yes?
Thank you so much, Madam Speaker. I think we still had an issue to deal with. And the Honorable Attorney General had asked which institutions we think can be merged. Our argument is there's National Council of Higher Education. Now we are creating a council for technical institutions. Yes, they have said the teachers we should not discuss. but chances are that we are also going to have a council for teachers. Those are 3 councils under one sector. Yet a few months ago, even a month ago,
why are you legislating in anticipation?
Okay, let me not include teachers. Let me deal with the technical institution that we are dealing with now, and the higher institution, the Council for Higher Institution that is already in existence. Madam Speaker, these are 2 councils that already need technical heads. Here we are creating an executive head. We already have an executive head for National Council of Higher Education, and they are all under one sector. And we've just been discussing rationalization and saying that in any sector, if we can have leadership under one umbrella, it does not matter whether they have different capabilities, but as long as leadership is concentrated under one institution. So my argument still is we need to first clarify that before we move to the actual bill, the technicalities of the bill.
Thank you, Right Honorable. I am reinforcing his point, Right Honorable. In the Ministry of Works, and I'm also referring to the information given to me by my honorable colleague, Honorable
John
SG. He is saying that there are different functions to this effect. In the Ministry of Works, you have a chief engineer. And this chief engineer is reported to by all the engineers in the...
He's called engineer-in-chief.
Engineer-in-chief. Is reported to, thank you very much, Honorable Speaker, is reported to by all manner and sorts of engineers in that sector. From mechanical, electronic, even those that deal with planes, they all report to an engineer. What takes precedent here is that he understands the basics of engineering, and he can be able to preside over the overarching issues of the sector. And this is in the spirit, and having understood the spirit of rationalization, we are helping the ministers not to come back here for another rationalization on the same matter that we can prevent now. Thank you very much.
Shadow. Honorable Sewongo.
Madam Speaker, I was following the honourable member, Honourable Semujuzi neighbour with their own fun here around sometimes. But you see, this bill, I would pray, Madam Speaker, if we do go for the debate of the report, then when you go to the real bill, you will be looking at those clauses that you want to amend. Because we are mixing. Already the Ministry of Education has one accounting officer. That's the permanent secretary. And he's only accounting officer, Ministry of Education. Others have votes and others, but they're still under Ministry of Education. But if we go to the real report, and then we, after close by close, we shall look at those particular areas.
Motion.
Because we are not the ones...
So you move a motion.
Madam Speaker,
yes.
the motion is moved by my brother minister. So I would pray if we could go for the debate, and after the debate, all these things will be looked at within the bill.
Honourable members, yes, Max.
Right Honourable Speaker, thank you for this opportunity. Right Honourable Speaker and honourable colleagues, I listened to the presentation, and I realized that the presentation focused largely on the bill and took for granted the certificate of financial implications. Our rules of procedure, and as well as the Public Financial Management Act, provides...
Why do you say it took for granted a certificate of financial implication?
I mean,
because when he was laying the minutes, he said, I'm laying the minutes together with the certificate of financial implication. So did you look at the certificate? Did you get the defect on the certificate?
I expected the report to interrogate the certificate of financial implication, because subsection 2 of section 118 of our rules of procedure requires us mandatorily to find out whether the bill has got positive or harmful effect on the economy. That's subsection 3. While subsection 2 requires us that we ensure that the certificate of financial implications provides a medium-term estimate of not only revenue, but expenditure as well. And in total, it should actually guide us whether the bill in question or under consideration is harmful or beneficial. Unfortunately, I did not hear that.
You know, if it is not reported that there was a defect, then the presumption is that it was sufficient.
Yes, thank you, Madam Speaker. Madam Speaker, whereas the Honorable Seungu had given a view that we go to the committee stages. I mean, okay, fine. In that case, I want to raise a clarification still on the same issue. It seemed to be pointing to two directions. The argument that why don't we have only National Council of Higher Education? The question here will be that are all technical schools under the category of higher education? Are there no technical schools that provide certificates? Because for me, yes, for me, my understanding is that when we talk about Council of Higher Education, it regulates institutions that provide from diploma level to university.
We even have these skilling,
yes, yes,
skilling centers.
Yes, Madam
where
Speaker.
Informal.
Yes.
Where you get somebody that's not even gone up to P7.
Yes,
and
Madam.
The person is.
Yes, Madam Speaker. So I think the argument and the push by members that we should leave the whole thing to National Council of Higher Education, for me as an individual, I don't support it. Because not all these technical institutions are categorized under what? Education, I mean higher education. Though one will argue that for others, maybe where they were saying the issue to do with the provision of basically issues to do with the national curriculum, education areas, one will say, okay, why don't we also second people with technical skills? But still, that one may not help us. I think the basic will be for us to separate this, have the what? Have the technical, vocational, and education and training council as on its own, and the other one of higher education will also deal with a different one. Thank you, Madam Speaker.
Thank you, Lillian.
Thank you, Right Honorable Speaker. I'm a committee member. I just wanted to give information from the issues that were where they wanted clarification on. Right Honorable Speaker, this bill actually merges a number of entities that had different accounting officers. In this bill, the Uganda Nurses Examination Board is being merged here. The Directorate of Industrial Training is being merged here. The assessment body for the allied, that section of the paramedics and all that is being merged here. So all of them will be under this one council. Actually, there are almost 4 entities that had different accounting officers, which will be merged here, and there will be one executive officer who will be supervised by this council. So let us not look at it that it is a standalone. We're actually merging many things into one. This council will be the body to oversee it. Thank you.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, whereas it is good to bring these institutions together, my attention has been drawn to the TVET delivery, which remains underfunded, and it is mentioned so in the bill. Right Honorable Speaker, with the high unemployment in this country, government should actually focus on promoting technical vocational training in this country. However, Right Honorable Speaker, when you look at 109, and of course considering that this vocational training is actually expensive, and Right Honorable Speaker, I at some point placed on your table a motion so that we can discuss and ensure that government funds not just the diploma TVET sciences courses, but also the certificate courses. Now, when you look at Section 109, Right Honorable Speaker. This section proposes to establish a skills development fund. And Right Honorable Speaker, I would have had no problem with this fund. But considering that we are here rationalizing the Uganda Road Fund, and yet all these other things that government is planning, even this vocational
what
training.
What is the relationship between Uganda Road Fund and the skill development?
Right Honorable Speaker, what I am trying to state is that under this, there is supposed to be established a skills development fund. And this fund will be financed by monies appropriated by Parliament, a levy on gross annual revenue of the TVET provider, and other funds that are listed here. So, Right Honorable Speaker, the point I am trying to bring is that we have the Higher Education Students Financing Board. And this Higher Education Students Financing Board has not only been funding students that qualify to go to universities, but
yes,
also...
Chair.
Thank you very much, Honorable Saro Pendi. I would like to give information.
Can I complete? I've not allowed you. Because it is
I have allowed him.
Right Honorable Speaker.
I have allowed him because you're deviating. You're deviating from the...
No, I'm talking about what is in the bill.
How is the financing board coming here?
Right Honorable Speaker, I am talking about a fund. And if in the Ministry of Education, we already have the Higher Education Student Financing Board, why don't we put money under this Higher Education Student Financing Board in the ministry, rather than establish another fund? That is my point, Right Honorable Speaker.
Honorable Sarah, this is going to be housed in the Ministry of Education and Sports. It is not a standalone. Yes?
Before the motion, Right Honorable Speaker, I would like to give Honorable Sarah Pendi information that this establishment of skills development fund is by the private practitioners who are saying that they want to contribute money but not putting it under consolidated fund. They want this money to be used to train the Juakalis for better quality and for the demand of what is required to create money. So in a way, it's the private manufacturers who would like to have this fund. And this fund is meant to train their very people who are trainers of other trainers. So it is not similar to the road fund and something like that.
Honorable Bigava.
Thank you, Right Honorable Speaker, for the opportunity. And Right Honorable, I want to thank the committee for processing this bill, which I regard a very important bill, Right Honorable Speaker, because that is my background. Right Honorable Speaker, I only want to know from the committee why on the technical side they did not engage the Uganda Engineers Registration Board and the Uganda Institution of Professional Engineers. Why am I saying so, Right Honorable Speaker? One of the objectives of this bill is to regularize and license a group of cadres called craftsmen, technicians, and technologists. And Right Honorable Speaker and colleagues, technologists and technicians at the moment are licensed by the Uganda Engineers Registration Board and the Uganda Institution of Professional Engineers. So I'm wondering whether this is not going to be a conflict between two bodies. That aside, I want to appreciate the committee once again, Right Honorable Speaker.
There is a motion.
Right Honorable Speaker and honorable colleagues, I wish to move a motion that we proceed to committee stage, since it will give us an opportunity to interrogate the bill issue by issue. I beg to move, Right Honorable Speaker.
Is it seconded? Seconded. Seconded by Dorcas, by Dr. Pear, by Honorable Amwaka, by Dr. Chut, by Jane, by Acrobat, by Mbwa, by by Mapendusi, by Achora, by Honorable Nekesa, Honorable Alayo, Honorable Baka, Honorable Mbayo, and the whole side. I am putting a question at those who are in secondment of the bill going for the second reading. Those say aye to the contrary nay. The ayes have it.
The Technical and Vocational Education and Training Bill 2024, Bills Committee stage. Clause 1.
I put a question that clause 1 stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 2.
Chair.
Madam Chair, Clause 2 on application. Clause 2 is amended by A, inserting immediately after the definition of candidate the following. Certification means the formal process of crediting and the candidate with a record of his or her achievement. I beg to move, Madam Chair. B, by inserting in the definition of employer the words of or an employer of nurses, midwives, or allied health professionals after the word technologist. And then C, by inserting immediately after the definition of informal training the following: medical practitioner, and has the meaning assigned to in the Mental Health Act. And D, in the definition of a word of work, by inserting the word formally after the word employed. Justification, Madam Chair, for the definition of the world of work, the amendment is to provide clarity that the world of work is a formal environment, and 2, to provide for definitions of words that have been used in the bill to achieve clarity. Madam Chair, I beg to move.
Thank you, Minister.
Thank you very much, Right Honourable Speaker. Right Honourable Speaker and dear colleagues, I object to the proposal to amend the definition of the word of work. The rest, I agree with the chair, and I propose that the clause remain as it is in the bill, because the proposal complicates the envisaged reforms by only restricting employment to formal. Because when you look at TVET, there is that formal part, but there is also the informal part, which I think would be lost if we don't capture that. I submit.
AG.
Thank you, Right Honourable Chair. Right Honourable Chair, I tend to agree with Minister of Education, because I think the purpose of this act was to deal with some people who are not necessarily using formal letters of employment and etc. So I don't know whether the committee has looked at that for purposes of this act, for purposes of this act, let's not use the conventional definition of world of work. For purposes of this act, can we also allow those people who are working informally to also be considered in this space?
Thank you.
Just to add to what the AG has said, when you look at the definitions, it is categorical. Technologists practice, work, or are employed. So the word work itself need not be in formal employment.
Yes.
It encompasses everything. So I support the minister.
Okay.
Madam Chair, I concede.
I put a question that clause 2 be amended as proposed by the minister and supported by the AG and shadow AG. Those in favor say on the contrary, nay. The ayes have it.
Clause 2 as amended.
I put a question that clause 2 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 3.
Chair.
Madam Chair, I beg to move that clause 3 on objects of the act. Clause 3 is amended in paragraph F by inserting the word and license after the word regulate. Justification is to provide for the aspect of licensing of TVET trainers which was inadvertently left out. I beg to move.
Minister.
Thank you very much, Your Right Honourable Speaker. Right Honourable Speaker, I object. Chair, I object to inserting the word and license. This clause should remain as it is in the bill because regulation as a function is a broader and includes licensing. It is not necessary to tie licensing to regulation. I submit, Right Honourable Speaker.
Thank you. Doctor, engineer.
Thank you, Chair. Chair, I am back on the point which I raised when you are still. Chair, this clause provides for licensing of technicians and technologists. And the Chair, like I said, this is already a role that is being played very well by the Uganda Engineers Registration Board. So I do not know whether we are not creating a conflict somewhere.
So are you in agreement with the minister?
Yeah, on the point he was raising, I agree with him. But on this one, I'm very categorical.
Not on the committee. Yes, AG.
Thank you, Right Honourable Chair. The persons envisaged under this act cannot possibly be regulated by under the Engineers Registration Board. The persons who are envisaged here even include those who do not have any kind of formal education. If you look at the Engineers Registration Board Act, it requires you to have a degree in engineering, so it cannot. The idea here is to allow these people to sit in a space where they are amongst peers, and then the engineers can also do what their part is. So the engineers, what they were doing here, what they do is regulate artisan engineers. They are not these artisans. A person who has finished education as an engineer but has not yet registered as an engineer, you have a learning engineer, an artisan engineer who is under the pupillage of an engineer. That one will fall under the Engineers Registration Board. But these ones are different. Thank you.
Yeah, thank you, AG. When you look at clause 2 clearly, there are 3 categories of persons under this particular bill. The artisans, the craftsmen, and the technologists, and all are defined in accordance with this particular act. So those who are looking at engineers, surveyors, and the like, you are extending the application of this bill too far.
Yes.
Thank you, Right Honourable Speaker. Currently, we are handling the Engineers Registration Bill, Amendment Bill. and the category provided for here is
It's
not
not
taken
that.
care of. So
Yes.
I think it's very important that we reside them under this
Thank you.
bill. Thank you.
I put a question that Clause 3 stands part of the bill. There is no amendment. We are taking the original bill. I put a question that Clause 3 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 4.
I put a question that Clause 4 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 5.
I put a question that Clause 5 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 6.
Chair.
Chair, I have an amendment for Clause 6, the power of the minister. Clause 6 is amended in subsection 1 by inserting for the word may the word shall. Justification is to make it mandatory for the minister to give policy guidelines to the council. I beg to move.
Minister.
I concur, Chair.
I thought the Honourable Minister has responded quickly. Why should you be tied? What if you find you do not actually need to give guidelines? If you say shall, you are literally tying yourself, because you may reach a stage when you do not even need to give any policy guidelines.
And if the council is operating very well, you may not need to.
Actually, Right Honourable, when we discussed this, we actually realized that at the very beginning of this act, there will definitely be guidelines to be issued. So we will not be in breach of this. So we shall definitely issue guidelines under
So,
this section.
Okay.
We shall.
No, it's.
I will agree with the Attorney General as well. Because if you give him a discretionary powers, what if he's supposed to give and he refuses? So with the putting that clause with shall mandates him. So where they know, then he can't, but he should. But having discretionary powers of not doing what he's supposed to do sometimes causes challenges.
Okay, I put a question that Clause 6 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 6 as amended.
I put a question that Clause 6 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 7.
I put a question that Clause 7 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 8.
I put a question. Chair.
Madam Chair, there's an amendment on Clause 8 on the composition of the council. Clause 8 is amended by A, substituting for the words 66%, the word 2/3. B, by inserting immediately after sub-clause 2 the following. One of the employees referred to in subsection 1 shall be a manufacturer, and C, in sub-clause 4, by inserting the word in the fields referred to under section 30 after the word qualifications. Justification. 1, to the substitution of the word 66% with the word 2/3 is to use an appropriate terminology. 2, to specify that one of the employers proposed in the council membership should be a manufacturer, since they are bigger consumers of TVET services. And 3, to provide that the chairperson or member of the council shall have the qualifications in the TVET fields as specified in Clause 30. I beg to move.
Minister.
Chair, my chair is introducing something new which was not in the original position, where he wants to bring in a manufacturer. Today, a manufacturer could be the issue. Tomorrow is something else. So I want to propose, Chair, that the clause should remain as it is. The purpose of this subclause 2 is to only empower the minister through regulations to provide for the procedure or removal from office, but not prescribe additional grounds. However, if Parliament wishes to delegate to the minister power to prescribe additional grounds for removal of, then we introduce another element under any other grounds as the minister may prescribe by regulations. I propose, Chair.
Christine, then.
Chair, when the chairperson of the committee introduced the 2/3, I thought he was going to bring in the issue of gender. Because I feel the 66%.
It's covered under 5.
He wants to replace the 66% of the members appointed by the minister with the 2/3. I feel that this concerns the number of employees and not the gender. So I feel the 66 is okay to give minister powers to at least appoint this percentage. But Right Honorable Minister, the other issue of the Chair.
Check 5.
5 has been.
Yes. 6, 8, 6. 8, 5.
Yes.
8, 5.
He wants to delete the 66, the use of the language.
2/3.
So we should go for a fraction.
66 is just causing a uniformity, because all the laws that we have passed, we are saying 2/3, a third, and what we are saying, and what is saying in 8.5 is that 3 out of 6 shall be women.
Okay. Okay, so we wanted to be smart. My other one was on.
No, we are just having uniformity. We are only being smart in
my other one is on the proposal of the manufacturer. Based on the informal sector and the placement of our dual-card students, I am in tandem with the proposal that a manufacturer be included on this council.
Thank you. Thank you, Right Honourable Speaker. Honourable Chair. On the issue of introducing the manufacturer to be part of the council, we are all consumers of TVET service providers. From hotels to our homes, what is the peculiarity of this that you need to tie in manufacturers into the law? Because even all council members, by their nature, by their daily life, they are consumers of these services. So why do we need to tie in manufacturers to be part of the law?
Geoffrey.
Yes. Madam Speaker, I also want to agree with his argument, but also to add that this council, when we are setting it up, is supposed to regulate an institution that is in charge of passing scales. But a manufacturer, for him, is producing consumables. So how are these two related? So I wanted the chair to explain this. So for me, I don't agree with the proposal of the committee.
Chair.
Before the Attorney General, Madam Chair, when we interacted with the stakeholders, the manufacturer came and said that they needed to be vehemently.
Which type of manufacturer? Because they can even give alcohol manufacturer.
No, we got Uganda Manufacturers Association, so we didn't know whether he was from that.
The thing is
okay.
Not at that level.
Madam Chair, I would like to concede on that, but the other of arithmetic of 2/3 is okay.
No, that's okay.
Thank you.
That's okay.
Wanted to understand exactly what the chairman was trying to propose, because I see if he's struggling to bring in some skill or experienced person in that sector. Perhaps maybe we could create a clause that attracts a given experience of manufacturing to be part of the council.
Okwalinga, you know the problem when they're reading the report, you're not in. So you missed out in a number of these things. And when Lillian was making a clarification, Lillian, help him with the clarification.
I understand. Thank you, Right Honourable Speaker. If it was already clarified, then it's okay.
No, it
Madam
is.
Speaker. Yes,
On
I
the
concede.
Same, on the same when he has conceded?
I concede.
8.5.
Yes, I want to make a proposal, Madam Chair. Madam Chair, I'm suggesting under 8.5, they are talking about appointing members under Section 1 person to be a person with disability, 3 persons to be women. I wanted to bring a proposal that we have a youth leader on this council, because the majority of members that are going to be licensed.
But a woman can be a youth.
No, I think we should be specific with youth leaders.
A person of disability
national
can
youth
be,
leaders.
You see, like now here we are seated with the ministers, but we have a youth there who is a woman.
Madam Chair, when it's in the law, it will be very specific in the appointment. They will look for a youth leader. That's what I'm suggesting. I'm proposing anyway. A youth leader, because the majority of these people are going to be young people. The people who fall under this category.
Just look at the subclause 4. We've already provided the qualifications, professional qualifications and experience. So if your youth leaders do not have, they fall out.
Thank you very much, Shadow. Right Honourable Speaker, for clarity, we concede to the amendment of Clause 2 to include the 2/3. I agree with members that we should drop the proposed insertion. I just wanted to make an additional clarification to their proposal in Clause 5, because it says in the fields referred to in Section 30, it should be Section 30, Subclause 2. Okay. 30, Subclause 2. Because that's where the qualifications are placed, not the whole of Section 30. So it would read that a person shall not be appointed chairperson or member of council unless the person has professional qualifications, the field referred to in Section 32, and experience in delivery of TVET
That
service.
is 8.4, not 8.5.
8.4, yes, I beg your pardon.
Yes.
8.4,
Yes.
Clause 8.4, I beg your pardon.
Okay.
Thank you.
I put a question that Clause 8 be amended as proposed and amended by the Attorney General. Those in favor say on the contrary, nay. The ayes have it.
Clause 8 as amended.
I put a question that Clause 8 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 9.
I put a question that Clause 9 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 10.
I put a question that Clause 10 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 11.
Chair.
Madam Chair, Clause 11 have an amendment on disqualification of a member. Clause 11 is amended in paragraph B by inserting the words as ascertained by medical practitioner immediately after the word illness. Justification is to incorporate the requirement for ascertainment of infirmity of the body or mind. The medical practitioner before a member is disqualified from office on those grounds. I beg to move, Madam Chair.
The Minister.
I concur.
AG.
I concur.
I put a question that Clause 11 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 11 as amended.
I put a question that Clause 11 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 12.
Chair.
Madam Chair, Clause 12 about vacation of office of council. Clause 12 is amended by A in paragraph B by inserting the words as ascertained by medical practitioner immediately after the word mind, and B by substituting for subclause 2 the following: where a member ceases to be a member of the council in the circumstances which are not prescribed under subsection 1, the minister may, by regulations, prescribe the manner in which a chairperson or a member of the council vacates office under subsection 1. Justification: to incorporate the requirement for ascertainment of infirmity of body or mind by a medical practitioner before a member is removed from office. 2, for clarity, to indicate that the minister shall provide for other circumstances when a member of the council vacates office. I beg to move, Madam Chair.
Yes.
I also wanted to seek clarification on 12(6), subsection 6.
Let's first sort out 2, then you go to 6. Minister.
Chair, I'm not comfortable with the new development. There is something there he's inserting. It makes me very uncomfortable. Where a member ceases to be a member of council.
What is talking about his own procedure?
Under circumstances which are not prescribed under the subsection. Why don't we, if there is something we know that we will not have, why don't we give it its own clause? Otherwise, I'm praying that the clause should remain as it is. The purpose for the sub-clause 2 is to only empower the minister through regulations to provide for the procedure for removal from office, but not to prescribe additional grounds. However, if Parliament wishes to delegate to the minister power to prescribe additional grounds for removal, then clause 1b should be amended to include 7, which says any other grounds as the minister may prescribe by regulations.
Honorable Chair, I think the minister is very clear, and I've liked him. The committee is giving the minister powers beyond what Parliament.
Yes.
You want the minister really to go and legislate for us? So I agree with the minister. Let's retain the provision that they are, because sub-clause 12 is clear on the manner, the procedure in which the office can be vacated. But let's not extend the powers.
Yes.
Yes, Madam Speaker.
No,
the
just
issue.
hold on, let him concede.
Madam Chair, I concede.
Thank you.
So, Madam Speaker, what I was trying to raise is number 6.
Number what?
Roman figure 6, which
Where?
says a member ceases, like under conditions under which one can vacate, a council can vacate an office. Number 6 says ceases to be an employee or a member of the institution.
Which clause are you in?
It is still 12.
12 has up to 4.
B subsection Roman figure 6, where they say ceases to be an employee or a member of the institution or sector that he or she represents. It is as if for one to qualify to be a council member, he must belong to an institution where he is working to. But my thinking was that there could be some former employees, even possibly maybe people who have retired, but who have accrued knowledge in terms of issues to do with the technical knowledge. So don't those ones qualify? Must one only be working from an institution that he qualifies to be appointed to the council? That's the clarification I wanted.
I want you to look at 32. Those are the categories of people who will be in which, where the areas where people will be appointed from.
Yes, Madam Speaker, what I have understood what you are saying. the categories they have listed here: scaling development centers, vocational training institute, technical college, national polytechnic, or national technical university. So what was
32.
32. Okay. Yes, I've seen them. But still, Madam Speaker, that was the question I was trying to raise. Looking at, unless I have not understood it well, because when you look at this, still the implication to me is that you must belong to an institution. So what I was raising is, since we are dealing with the establishment of council members, say for example, if I worked in a technical institution, I have retired, I've accrued knowledge, can't I be appointed as a member? That's what I was trying to raise. Maybe it was, okay, please.
So just read, it's clear. You either belong to an institution, you are an employee, or you belong to a sector. Can you ever retire from your sector? 12(1)(b), Roman 6. So it speaks for itself, honestly.
Chair.
If you are looking at sector, then you go back to clause 30, sub clause 2. It gives you the sectors.
Chair.
Honorable Jeffrey, like if you refer to doctor there, he's a doctor. Even when he's a member of parliament, he still remains a doctor. He's still in that sector. Yes.
You'll find many parts in this act. For example, if you look at specifically 8.2 above, 8.2 says the minister, while appointing the members under subsection 1, appoint 2/3 of members from employers, including the chairperson. So what if this person who was appointed the chairperson ceases to be an employer? You have to remove him because he has ceased to represent the category for which he was brought into this council. So when that happens, if you say it won't happen, then the provision is not harmful, but it is possible that it could happen. Thank you.
Chair.
Yes.
Chair, the honorable colleague, the point he's raising is very important. Are we saying that once people clock age of retirement, will not be qualifying to be members on this council? Because, first of all, 8.4 only requires a person to have professional qualifications.
Age is not an aspect in this thing. It's not an aspect in this.
Chair, it's a given because it's saying you should be employed in an institution. So age is a given that once you are not employed.
Or belong to a sector, belong to the fraternity of medics, belong to the fraternity of lawyers. You get it, even when you're not practicing. Yes, Jacob. Jacob.
Thank you, Madam Chair. I will give a simple...
Thank you, Right Honourable Speaker. Mine is just, I wanted a clarification from the Attorney General on 1A, which just talks about resigns. There's a tendency of some people when, for example, he knows that he has committed an offense and then he resigns. Wouldn't we be able to put here that until accepted by the minister, that it should be when you resign, the minister should accept your resignation? Because we may want you there.
Look at 12.1. 12.1 on resignation. There is 1, 2, 3, and 4. It will show you for misbehavior or misconduct, inability to perform your functions. It's already catered for.
But there is where somebody, what I'm trying to address is that somebody has committed an offense, but the institution is not yet aware. So this person goes ahead to put a resignation to leave. Because when you resign, you may be qualified to get some of the benefits. But if you resign and you are subjected to be accepted, your resignation should be accepted first before you vacate office.
Check 6.
Okay.
Right Honorable Chair and Honorable colleagues, resignation is both factual and legal. So when you have a contract with someone which gives you the terms under which you're working, you cannot just leave them by just simply saying, I've decided to resign. Even that, you are supposed to give him a notice of resignation and all that. And while you're still in that period of notice, you're still an employee and you can be dealt with. In any event, if you leave and they still find you culpable, you will still be held culpable. And I think this one is sufficient. It is okay to say when a person resigns, but also if a person has committed a wrong and they decide to resign, haven't they saved you the bother of having to fire them? Thank you.
Thank you. I put a question that clause 12 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 13.
I put a question that clause 13 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 14.
I put a question that clause 14 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 15.
I put a question that clause 15 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 16.
I put a question that clause 16 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 17.
I put a question that clause 17 stands part of the bill. Those in favor say on the contrary, nay. You can't even say aye. Are you too hungry? I put a question that clause 17 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 18.
I put a question that clause 18 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 19.
I put a question that clause 19 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 20.
I put a question that clause 20 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 21.
I put a question that clause 21 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 22.
I put a question that clause 22 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 23.
I put a question that clause 23 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 24.
I put a question that clause 24 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 25.
I put a question that clause 25 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 26.
I put a question that clause 26 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 27.
I put a question that clause 27 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 28.
Chair.
Madam Chair, I have an amendment on 28, development of TVET qualification framework. Clause 28 is amended in subsection 4 by substituting for the word 3 to the word 5. Justification: the substitution of the number of years for review of the TVET qualification framework of 3 years with 5 years is to minimize costs. I beg to move, Madam Chair.
Minister.
I concur, Madam Chair.
AG.
The minister has concurred, I concur. It's too technical for me, this one.
I put a question that clause 28 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 28 as amended.
I put a question that clause 28 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 29.
Chair.
Madam Chair, clause 29 is amended by A in subsection 1 by substituting for the words formally or informally the words through informal training and formal training, and B in subsection 2 by substituting for the words informal delivery, the words informal training, and C in subclause 4, by substituting for the words informal delivery, the words informal training, and then D in subclause 5, by substituting the words 250, the words 150, and C by inserting immediately after subclause 2 the following: where a body corporate commits an offense under this section, the body corporate is liable on conviction to a fine not exceeding 250 currency points. Justification to use the terminology defined under clause 2 of the bill instead of introducing new terminology. 2, to introduce a penalty for a body corporate. I beg to move, Madam Chair.
Honorable Minister.
Thank you very much, Chair. Chair, I'm a little bit uncomfortable in the subclause 1.
First of all, Chair, you're introducing informal and formal to only training, which looks limited. Then when you look at 4, delivery, you want to turn delivery into training. Minister.
Chair, exactly that's where my problem is. Subclause 1, B subclause 2, and subclause 4. I want to pray that this remains as it is in the bill. This is because the delivery, as you said, Right Honorable, has 2 aspects of education and training. If training alone is adopted, then the element of knowledge acquired through education aspect will definitely be lost. Madam Chair, I submit.
AG, Father Shadow AG.
Yes, Madam Chair, in addition to that, even the proposed amendment by way of inserting a new clause to fine a body corporate 250 when he has amended for another person 150 is discriminatory, and the person in the law includes both natural and artificial. So the entire proposed amendment should be abandoned and the clause be maintained as is in the bill.
When you look at the formal kind of what is happening on social media, there is where they say do it yourself, DIY. I put a question that clause 29 stands part of the bill.
Yes, I've considered, Madam Chair.
Okay.
This section introduces the issue of informal education. And then on 4, you are saying somebody who has been trained informally cannot be given employment in any world of work.
Who says? Unless they have been assessed and certified.
The reason why I'm saying this, Right Honourable Speaker,
by the TVET Assessment Board in accordance with the provision of this Act.
Some of these people who are trained informally may not even know, are not fully literate to undergo an assessment, but they have the skill to do the work.
This is practical.
Chair.
Practical, okay.
Chair.
I concede.
Chair, if I could.
I put a question that clause 29 stands part of the bill. Those in favor say on the contrary, nay. Nice have it.
Clause 30.
Chair.
Madam Chair, we have an amendment in clause 30, categorization of formal TVET providers. Clause 30 of the bill is amended by A, in subclause 1, in paragraph C, by inserting the words, including colleges of health sciences. B, in subclause 2, in paragraph B, by inserting after the words business, the words and management. And 2, by inserting immediate after paragraph F, the following. Any other as prescribed by the minister. And C, in subclause 5, by substituting for the word may, the word shall. Justification to include the aspect of management under TVET fields of TVET. 2, to give room for the minister to establish other fields of TVET. And 3, to make it mandatory for any university, other degree awarding institution or tertiary institution established under the Universities and Other Tertiary Institutions Act to be accredited under this law. I beg to move, Madam Chair.
Where are you including colleges of health sciences? On 1C. Because the College of Health Sciences provide the degrees.
Madam Chair.
Yes.
Thank you, Honorable Chair. I would like the Chair to clarify the issue of Skills Development Center and Vocational Training Institute. The categorization leaves out a lot of other institutions that fall under this category, because if you have a vocational school, it's actually different from an institute. The institute is meant to train people from senior 4 and above, I'm told. And then there is a school which is meant to train these other ones who have not reached senior 4 or those informal. Then the development center is usually for the civil society organizations that use that. So that word institute leaves out so many other vocational schools in our communities.
And when you look at 2, where you say business education and training and management, how is management coming in? Then you say any other as prescribed by the minister.
Chair, that's where you had the problems with my chair. And I'm saying that the clause should remain as it is in the bill. Because when you talk about management, it's an application of skills, knowledge, and the competences one has acquired. Secondly, this is an international nomenclature. This is how these things are when it comes to TVET. B, the clause should also remain as it is. This is because the list of broad fields in TVET is exhausted as per the international norms. I submit, Chair.
AG.
Yes, Right Honorable Chair, the Honorable Member raised something which I pray that members, we are on the side of caution, so that tomorrow I'm not called here to say we closed out a certain category of person. That category you are talking about was what we had placed under the Skills Development Center, but you seem to hold the view that they are different. In order to play safe, can I propose, honorable colleagues, that we include an F and say any other category as prescribed by the minister in consultation with council, so that in case we find that any category that has been carrying out this activity has not been well taken care of, we can then go and have it prescribed under F.
F, eh?
Yes, so I was proposing that we put F in categorization. The former TVET providers shall be categorized as A, B, C, D, E, F, and any other as prescribed by the minister in consultation with the council.
Yes.
As may be prescribed by the minister in consultation with the council, just in case we have fallen short of a category, we have a space.
Thank you.
Secondly, Right Honorable Speaker, Right Honorable Chair, On the definition, as the minister said, again, G, I may want to agree with the committee. We are moving in a very, very fastly changing world, that we do not want to come back here and say the broad categories have now increased and we need to amend the law. So the proposal of G, as may be prescribed by the minister from time to time, allows this law to grow. In case other changes happen, the minister can as well categorize the new broad areas of study. And then in 5, I would like to propose that we leave it at may, because if you read 5 to say, subject clause 31 notwithstanding subsection 1, a university, other awarding institution or tertiary institution established under the University and Other Tertiary Institutions Act shall apply. You have made it mandatory for every university in Uganda to carry out TVET, whether they want it or not. Now this may allows them to decide. If they would like to run TVET activities, they would apply for accreditation. If they don't want, then they leave it at that. Yes. Thank you. Yes, please.
Madam Chair, I want to thank the Attorney General. Actually, you have catered for our clause, and the minister will be safe, as you've said. But what we are putting in May, you know, many universities are coming up, and definitely they are going to compete. But someone might not be interested in having TVET. But if you make it mandatory in any university, what if it doesn't have the facilities to run TVET? And you might find the universities in maybe Karungu, Karamoja, but because of a competing business, to be on him. The moment you see that he's not getting business in the other fields of the education, he rushes. But if you make it mandatory, then when they are licensing them, they will be required to have all those necessities, which will be difficult for them.
You're repeating what was the position of the bill. That is what the bill says, may. It's not shall.
No. One had put in the word shall,
no,
and I was convincing him.
The committee had proposed shall, and I was making the case in agreement with you that we should keep it at may.
So you are very attentive. Thank you.
Yes.
Madam Chair, I do concede on this.
Honorable Chair, on this specific issue, where the Attorney General proposes may, what if we say that subject to Section 31, Clause 4, and notwithstanding subsection 1, a university, other degree awarding institution, or tertiary institution established under the University and Other Tertiary Institutions Act that is interested in offering TVET services shall.
Drafting. Honorable members, I put a question that clause 30 be amended as proposed by the Attorney General. Those in favor say and the contrary nay. The ayes have it.
Clause 30 as amended.
I put a question that clause 30 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 31.
I put a question that
the amendment the Attorney General just made has an impact on.
We have passed.
No, I'm not talking at.
Yeah.
The amendment he made has an impact on 31.2.
31.2.
Yes,
okay.
That's where we are. Because it limits definition of vocational education and training to only the first two that had been mentioned. But we've been mindful of other vocational levels that can be brought in. So it has an impact and needs to be revised. I beg that he helps because...
This one is we are dealing with levels, These are different levels. So if you're going to issue a certificate of national craftsperson certificate, you can only issue it under that category. It doesn't stop the others. So the accreditation given to the others, that may be prescribed. Because technical education training, you can see the different these are levels. So it doesn't have, not every TVET institution can issue a national craftsperson certificate. Not every one of them.
Attorney General, 31.2 is categorizing the above mentioned categories in 32 into two categories of awards. So they are classifying A and B into a lower category, then B, C, D, E, F into other categories. But now we have put there another subsection, H, that are giving minister opportunity to think of others. If we limit it and we don't define, give him opportunity of classifying those others either in a lower or upper, we shall have excluded them in their awards.
Yes, Mkatuli.
What you are saying in 31.2, read it carefully. The vocational education and training shall be offered through a skills development center or a vocational training institution accredited by the council to offer a TVET program leading to an award of a national craftsperson's certificate and below. So it must be having that element. Mr.
Hajat, what the proposal that AG brought should be in compliance with the two, with 31.2.
Chair.
Yes.
If you look at sub-clause 4 of that 31, I think it sorts you out, Hajat, because the reference to university or degree awarding institution shall not offer a TVET program leading to an award of a national higher degree, diploma or postgraduate diploma. So the awards are clear and which institutions to give them.
Clarification on the word, Chair. When you read that 2 and 4 that honorable member is raising, the award here is talking about craftsperson certificates. But there are categories like those who are training at the presidential skilling centers. Where are the certificates? Is it the craft still? It is not here. No, but craft is when you have reached senior 4.
Those are different. If they want it, they have to go through these projects.
My clarification on this is that where are we leaving the rest of the category? What certificates are they going to get?
I think let's draft. Let me try and
General,
draft.
if you could just take this and redraft at once. If you could just...
You see, like when you look at one A and B, lower TVET known as vocational education and training, and upper TVET known as technical education and training.
Chair, the point you are making, if you can help me, honorable colleague, the 31.1 only envisages lower TVET as only being that is at vocational schools. What? Only being technology education trainings? No, only being at skills development center and vocational training centers. But we are also aware that there are children that have been going through some vocational training after primary 7, which graduates them into joining technical schools. That kind of award is not looked at here.
That is a...
So...
Chair, if I could make my point and you take all at once. I think the matter she raises is very important. Before, there were cases where people would go through Directorate of Industrial Training and they will do their skilling in whichever trade and be able to get a certificate of DAT. Arising from the current proposal, it would seem that which used to happen and has been very helpful in the societies will be omitted. And the clarification we wanted to get, the clarification I wanted to get, which would also address the concerns of the other colleagues, is does the national craft person certificate offer and cater for those trades which the DAT has been certifying? Yes. If it does, that is okay. If it does not, then we have a problem.
I think
just a minute, AG. Let me first have a direct. He used to be a director of DIT.
No. Uganda, before in 2015, Uganda Business and Technical Examinations Board. Madam Chair and honorable members, let me allay the fears of colleagues, because the concern is there are those people who are training in presidential skills hubs. There are those who have never been to school and others. If you go to clause 28, we have the development of TVET qualifications framework. And when you go to 28.3D, 3 says the TVET qualification framework developed under subsection 1 shall provide for level of qualification or competences attained at every level. Now, in this one, under the vocational qualifications framework, it is going to define the different levels that someone has attained, whether in informal or formal training. And in that arrangement, those people will be catered for. Yes, everything to be catered for here.
I don't think you have answered. Chair, this is an important matter which affects many Ugandans.
Yeah, let me redraft.
Maybe before you redraft, he has contradicted it further.
No, he hasn't.
No, he hasn't.
He
hasn't.
I think I've understood what the honourable member was raising. The issue, if I understood it, Honourable Aisha, properly, is that in case tomorrow you accredit another institution which is not a skills development center or a vocational training institute, what will happen? So I'm proposing to redraft as follows. The vocational education and training shall be offered through a TVET provider accredited by the council to offer TVET program leading to an award of national craftsperson and etc. Because here in 31 we added that the minister may from time to time, if we have left out any category, put it there. I think that's what their concern was. So if you say by a TVET provider accredited by council, yes. So whoever you have in whatever category, all they have to do is go and get accredited, and then they can issue the yes. Thank
you. I put a question that is section 31, clause 31, be amended as proposed by the Attorney General. Those in favor say on the contrary, nay. The ayes have it.
Clause 31 as amended.
I put a question that clause 31 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 32.
Clause 32, Madam Chair, I have an amendment. Establishment of public TVET provider. Clause 32 is amended by substituting for the word may the word shall. Justification to make it mandatory for the minister to establish public TVET providers. I beg to move.
Right, Honorable Chair, I want to object. The moment it's advice, the person who is receiving the advice must be left with the option of accepting the advice or rejecting the advice. And therefore, the person who, when they've rejected it, may have the option of appealing. But we cannot say that once I give you advice, you must follow it. So I think we should leave it at may on the advice of council. And if they are not aggrieved by that, we have made provisions for the necessary appeals. Thank you.
I put a question that clause 32 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 33.
I put a question that clause 33 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 34.
I put a question that clause 34 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 35.
I put a question that clause 35 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 36.
I put a question that clause 36 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 37.
I put a question that clause 37 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 38.
I put a question that clause 38 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 39.
I put a question that clause 39 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 40.
I put a question that clause 40 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 41.
Chair.
Madam Chair, I have an amendment on clause 41. Grant or refusal of accreditation. Clause 41 of the bill is amended in clause 1 by substituting for the words the time prescribed by regulations the words 6 months. B, in subclause 3 by substituting for the words the time prescribed by regulations made by the minister the word 1 month. Justification to prescribe the time within which the council can grant or refuse to accredit a TVET provider in the parent law and not in the regulations. 2, to prescribe the timeline within which the council can consider an application of accreditation of a TVET provider in the parent law and not in the regulations. I beg to move.
Minister.
Chair, I agree with my chair.
AG.
Right Honorable Chair and Honorable colleagues, I am not very hard on this issue, and as you can see, the minister has considered. However, I must caution that these timelines that we are putting, that the council shall within 6 months after receipt of an application, there are different categories of TVET in this law, from easy to difficult. So you have said that even when the thing is so easy to deal with, the minister must deal with it in 6 months. Within 6 months. Yes, but you see, there are some which I think, in my view, should have been within a month. Listen, what I'm saying is that it is always good to give a duty. If, for example, you are requiring these regulations to come before Parliament in a certain time, to be laid before Parliament in a certain time, it would be good. But this one size fits all in this kind of area, it is not advantageous. So what I was proposing, colleagues, this is an area which is growing in this country. 3 years ago, where we had TVET and where we have it today as a high priority area has changed. And we are going to have to constantly keep re-engineering ourselves in this space. And therefore, our continuous management of regulation in this area is going to be extremely important. Now, I am imploring you members to allow for regulations to be made for the different categories of TVET institutions that are going to be governed by this law. There are some that are fully established by now. There are others which are growing. There are some which are so informal, which need to be brought into the formal spacing. I am proposing, colleagues, that the provision be left as it is, so that we can go and be able to make different regulations for the different circumstances that obtain. I beg to submit.
Thank you. Yes, Minister.
Actually, Chair, that was my mind at first, our mind as a ministry. But in the spirit of win-win, it was very difficult to come up with this document. In the spirit of win-win, that's where we agreed on that as something that was binding both sides.
Chair.
Madam Chair, given the explanation of the AG, I concede.
Let's look at the regulations that shall be made by the minister because of the changing kind of. I put a question that clause 41 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 42.
I put a question that clause 42 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 43.
I put a question that clause 43 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 44.
I put a question that clause 44 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 45.
I put a question that clause 45 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 46.
I put a question that clause 46 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 47.
They should bring for you for water so that I can hear your voices.
Clause 47.
I put a question that clause 47 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 48.
I put a question that clause 48 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 49.
I put a question that clause 49 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 50.
I put a question that clause 50.
Thank you very much, Madam Chair. Madam Chair, when you look at the principal, the deputy principal, the registrar, they are all appointed by the Public Service Commission. However, when it comes to trainers and other staff, Madam Chair, the trainers and other staff, under clause 50, section 50, it states that they shall be appointed by the governing council. And Right Honourable Speaker, I have a problem there. Because why should the principal, the deputy, and others be appointed by public service? I'm trying to compare this with what goes on in other institutions of government. Because when you come to the national teachers, it is Education Service Commission. So why are we now asking the governing council to be the appointing authority for the trainers in these TVET institutions? Why don't we leave it to the public service?
Just a minute. You read the whole line, the whole paragraph. The trainers and other staff of TVET providers shall be appointed by the governing council in accordance with the human resource management standards for the recruitment section and appointment of TVET trainers and staff of TVET providers developed by the council. Now, you're talking about public service as if you're dealing with the universities, those kind of things.
Madam Chair, I want to find out from the minister, because we equally have had issues and problems when we try to, separate the appointing authorities in institutions. Why don't we leave this to either the Education Service or the Public Service Commission? If the registrars, the principals and deputies are appointed by public service, I want to find out from the minister, why can't they, the trainers, also be appointed by the same Public Service Commission? I just want to find out.
And not all these providers are public.
Okay, I'm talking
Some
about
of them are private.
Yes, those in public institutions. Why don't we leave it to the Public Service Commission?
Additional question for the minister.
You can't state here. You'll bring it in the regulation.
Additional question for the minister.
Madam Speaker, I want the minister to explain.
Minister, you will respond to this together.
The
I
explanation
have seen you provide for polytechnics and the National Polytechnic and the Technical College. But earlier on in 32, we also defined the skills development centers and vocational institutes, are we avoiding also providing what kind of people must head those institutions at this point?
We were still at 50, then you went to 51. But if you look at the management of TVET institutions, if you look at part 8, it deals with the management of TVET Technical College, National Polytechnic, and Technical University. So then you have National Technical University. So they're different. So they're just giving you the structure of all of them. It's one structure. They are uniform. But on the issue of Honorable Saro Pendi, even this is akin to what you have in the university and other tertiary institutions. These institutions are not they are technical institutions, but they are not necessarily similar in all forms. You could have a science university, and you could have an arts university, a humanities university. Now, even here, you can have a technical institute on welding, you could have a technical institute on plumbing, and the governing council that has been put there is technical in that space, and therefore is a better place to find the technical people to train in that space because of that kind of structure.
Honorable members, this clause is talking about a standardization of recruitment, which must be followed whether you're in private or you're in public. I put a question that clause 50 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 51.
Chair.
Madam Chair, clause 51 is amended in A, sub-clause 3, by substituting for the words 3, the word 4.
You know, the problem is, honorable members, if you've just come in, refer to the previous clauses. Refer to the previous clauses.
Then
Yes.
B, in sub-clause 4, by substituting the word may to the word shall. Then C, by inserting immediate after sub-clause 2 the following. At least 1/3 of the members of the council shall be women. That is for Honorable Christine, I think, there. And D, by inserting immediately after sub-clause 3 the following. Following the end of tenure of a member of the governing council, the member of the governing council shall ensure a smooth transition for the new governing council. Justification: the tenure of governing council has been amended to 4 years to tally with the tenure of the TVET council. And the 2 of the justification, the subsection of the word may, the substitution of the word may with the word shall, is to make it mandatory for members of the governing council of TVET colleges, National Polytechnic or National Technical University to be paid allowances. And 3, to provide for women representation to cut across any position on the council and not only one position as it was proposed in the bill. Then 3, to ensure a smooth transition between the incumbent governing council and the incoming council. I beg to move.
Minister.
Chair, there is where I agree with my chair, especially about moving from 3 to 4, but I'm not happy with him under B, with that word may. Of course, my prayer is that the clause remains as it is. This is because payment of allowances is subject to availability of resources. Members of council should not be paid a mandatory allowance, Madam Chair. Of course, some may not have the money to do that, The other way where I'm objecting is inserting immediately after the clause 3 the following, those what you mentioned there. And I'm suggesting here that this clause remain as it is. This is because the provision is not implementable, ladies and gentlemen. It is not necessary, even not necessary. This is administrative measure and not legislative in nature. I submit, Chair.
Chair.
Shadow.
Yeah, in addition to that, Madam Chairperson, this particular clause applies both to private and public bodies. Now you start increasing numbers on a private body who will be entitled to allowances and the like when most of them tend to be struggling. I would invite the chairperson to reconsider his position. We maintain the numbers as in the bill.
Chair.
3, not 4.
Chair.
Let's get from Daudi first.
Mine was on the insertion of the new clause that says following the end of the tenure, the new governing council, the member of the governing council should ensure a smooth transition of the new governing council. I don't think that this is necessary.
I think that is implied.
It is really implied. It is a given that when a council ends, a tenure ends.
That is implied. It doesn't have to be in the law.
Yes, you cannot say ensure.
Chair.
Should not.
It has no harm at all. We have had challenges on transitions. And you know that, Mr. Attorney General.
It is like saying that once we change Honorable Seungu from Kosase, from Shadow, we should make sure that he should do ABC. No, it is implied. Hanover, you have to do it.
Chair, my comment, Chair, my comment particularly on that one. I agree with the Minister that it's not enforceable. First, you cannot tell the exiting members to be the ones ensuring smooth transition. Suppose they don't want to ensure. So it's a redundant insertion. It has no effect. We don't.
Yeah. Madam Chair, maybe let the chair of the committee let us inform us what informed that clause.
We are making a law. You also.
Madam Chair,
Honorable members.
I concede on
Honorable
B.
member. On all.
No, the one for years, the minister is in agreement from 3.
No, it's not in agreement.
On the first year about years?
AG has guided. AG, are we?
I think what Honorable Nwagaba raised here is very important. You must take it into consideration that these universities, some of them, these institutions are private. So the longer you make these councils exist, so if you tell him the council must be for 4 years, what if the business is collapsing in year 2? What happened? So, and on the other one of at least 1/3 shall be women, that is perfectly fine. And the one of May, we have agreed that should return back to May because some people are doing it for free in their private in councils.
So there is no amendment at all.
No.
Clause 51. I put a question that clause 51 stands part of the bill. Those in favor say to a contrary nay. Let's have it.
Clause 52.
I put a question that clause 52 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 53.
I put a question that clause 53 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 54.
I put a question that clause 54 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 55.
I put a question that clause 55 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 56.
I put a question that clause 56 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 57.
I put a question that clause 57 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 58.
Chair.
Madam Chair, clause 58 about boards of governance. Clause 58 is amended by A. In subclause 2D, by deleting the words, at least 2 shall be women. B, by inserting immediately after clause 2 the following. At least 1/3 of the members of the board of governance shall be women. C, in subclause 3, by substituting for the word 3 the word for, and D, in subclause 4, by substituting for the word may the word shall. Justification: to provide for women representation, to cut across any position on the board of governance and not only one position as it was in the proposed bill. 2, the tenure of board of governors of skills of a skill development center or vocational training institute has been amended to 4 years to tally with the tenure of the TVET council. 3, the substitution of the word may with the word shall is to make it mandatory for members of the board of governance of skills development center or vocational training institute to be paid allowances. I beg to move.
Right Honorable Chair, I implore members to allow that this provision remains as it is. We have just discussed this issue. Similarly, the issues that are raised on the earlier provision are the same. This bill deals with both public and private sector. So the amount of regulation you can do in private sector is not the same as you can do in public sector. But we know that in public sector, the rules on affirmative action are clear. So I pray that the bill, the provision do remain as it is in the bill.
Actually, 3 is consequential of the 51, of the 3 years.
Chair, I wanted to know, when you say local government, under lower local government, is it at the district? Is it the smallest at sub-county? Clause 58? Clause 58 2B.
The Local Government Act, 1997, defined.
Madam Speaker, for his information, wherever he finds lower local government, it refers to a division of a municipality, a town council, or a sub-county.
It is lower than the district as defined by the local. So what is there any change? So you want it to remain as it is?
I'm totally in agreement with the Attorney General.
I put a question that clause 58 sounds part of the bill, those in favor say, and the contrary, nay. The ayes have it.
Clause 59.
I put a question that clause 59 stands part of the bill, those in favor say, and the contrary, nay. The ayes have it.
Clause 60.
I put a question that clause 50 stands part 60 stands part of the bill. Those in favor say, and the contrary, nay. The ayes have it.
Clause 61.
I put a question that clause 61 stands part of the bill. Those in favor say, and the contrary, nay. The ayes have it.
Clause 62.
I put a question that clause 62 stands part of the bill. Those in favor say, and the contrary, nay. The ayes have it.
Clause 63.
Chair.
Madam Chair, clause 63 is amended by inserting immediately after subclause 6 the following. Notwithstanding subsection 1, the person may be exempted from the requirements of registration in accordance with section 74. Justification: to provide for persons exempted from registration as prescribed under section 74. I beg to move.
Minister.
Chair, I have no objection.
I have no objection to that insertion.
I put a question that clause 63 be amended as proposed. Those in favor say, and the contrary, nay. The The ayes have it.
Clause 63 as amended.
I put a question that clause 63 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 64.
Chair.
Madam Chair, an amendment on 64, issuance of certificate of registration. Clause 64 is amended in clause 1, subclause 1, by substituting for the word may the word shall. Justification to make it mandatory that when the council is certified that an applicant is eligible to be registered or to register, the council shall enter the person's name in the register. I beg to move, Madam Chair.
Minister.
Chair, I agree.
AG.
I agree with Honorable Chair.
I put a question that clause 64 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 64 as amended.
I put a question that clause 64 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 65.
I put a question that
Chair. Thank you so much, Chair. The problem I see with 65, the heading is talking about suspension and cancellation of a certificate of registration. Sorry? Cancellation. Oh, okay. Thank you. 1 talks of suspension. 2 talks of conditions for cancellation. In here, 65, they don't talk about conditions of cancellation, of suspension, but they talk about conditions of cancellation. And yet, in the following one, they determine a suspended certificate as a cancellation certificate, cancelled certificate. I find a problem. For the benefit of the colleagues, 65.1, the council may suspend a certificate of registration for such period as may be determined by council or until TVET trainer complies with the conditions determined by council. But in 2, they only speak about conditions for cancellation. They don't talk about conditions for suspension. And when you go down in 66, suspension is equivalent to cancellation.
No.
Can
Suspension is not equivalent to cancellation. Suspension is when an investigation is still going, when there is a presumption that maybe it is a breach. But now on cancellation is when you have a prima facie case and say this one went wrong and we must cancel.
Chair, you are indeed right. When you read 66, a registered TVET trainer whose certificate of registration is suspended or cancelled shall, for purpose of this act, be taken to be registered, not to be taken to be registered from the date of suspension or cancellation of the certificate of registration. That means a suspended person is treated the same way the cancelled person is treated.
A suspension.
Pending investigation.
Yeah, suspension is for a definite period. You can suspend and say you're suspended for so long. Cancellation is that right has been taken away. But I think here what you're dealing with here is that the council may suspend a certificate for such a period as may be determined by council. As for such a time as may be determined by council or until the TVET trainer complies with the conditions. So that is, it's like interim, but cancellation is more definite.
In your sense, what we are saying, Madam Chair, is that this ministry doesn't want you to lose your business and job. So when they are suspending, they are giving you room to correct your errors. So there is no defect in this.
Chair, I rose on clarification. I just want to understand that the conditions for cancellation, because in 1, they talk about suspension for a definite period of time, that is clear. In 2, they're talking about for term conditions for cancellation. So they are not giving any conditions for suspension.
You see, a suspension is a punishment which is minor.
Which may lead into a cancellation.
And cancellation is more serious. That's why a suspension under 65(1), we are not providing for the terms, the conditions for suspension, and leaving it to the council, because it's for a definite period of time and it gives you reasons why you've been suspended, giving you time to correct them and start operation. But for a cancellation, the grounds must be clear. So I think the bill is clear. Yeah, in the 2. Yes, cancellation is under 2, suspension is under 1.
I concede, Chair.
Thank you. I put a question. I put a question that clause 65 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 66.
I put a question that clause 66.
This is under 66 is where we need to separate from the suspension, the punishment for suspension and that of cancellation. We need to define that this is at least not at the same level. No.
What this clause is simply telling you, it is telling you that for the period of suspension, you cannot perform the functions under this TVET Act. And for the period of cancellation, you cannot. So for the period of suspension, you can't do TVET activities. If your certificate is cancelled, you can't do. So they are telling you, while this one is periodic, the other one is longer, permanent.
I put a question that clause 66 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 67.
I put a question that clause 67 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 68.
I put a question that clause 68 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 69.
Chair.
Madam Chair, clause 69 under TVET training license. Clause 69 is amended in subclause 3 by inserting the word or the words except as provided for under section 74 after the word Uganda. Justification is to provide for persons exempted from licensing as prescribed under section 74. I beg to move, Madam Chair.
Minister.
Chair, I have no objection.
AG.
No objection.
I put a question that 69 be amended as proposed. Those in favor say the contrary nay. The ayes have it.
Clause 69 as amended.
I put a question that clause 69 as amended stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 70.
I put a question that clause 70 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 71.
I put a question that clause 71 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 72.
I put a question that clause 72 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 73.
I put a question that clause 73 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 74.
I put a question that clause 74 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 75.
Chair, I seek to understand where 75(1)A leaves our normal craftsmen who are training our people. When we generalize and say a person who not being registered as a TVET trainer or otherwise authorized under this act holds himself or herself out of the TVET trainer, whether openly or covertly, where does it leave these other people where we take our people to train, like the garages? Where does it leave them?
Do they have a license?
If you take them to a garage which doesn't have a license to train, and that person does not say he's a TVET trainer, he has not committed an offense. But if he holds out to be running a school and an institution. And really, this is a reality right now, because we have people who attend institutions and then at the end of the day they cannot get certification. Then it becomes a problem. These people told me they're a school, I'm supposed to get my certificate, and they could not. So that's the offense. So, but I think what we need to do is, if we find those people who have skills, it is to encourage them to get this certification so that they can issue these.
Chair.
Honorable members, I thought that's why we are making the law. I put a question at clause 75
Chair,
stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 76.
I put a question at clause 76 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 77.
Chair.
77, Madam Chair. 77 of the bill is amended by inserting the word Uganda before the words Health Professions Assessment Board and wherever it appears in the bill. Justification is to specify that the Health Professions Board is for Uganda, as it was specified for the Uganda Vocational and Technical Assessment Board.
Minister.
Chair, I have no objection.
AG.
No objection. Right,
I put a question at clause 77 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 77 as amended.
I put a question that clause 77 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 78.
I put a question that clause 78 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 79.
I put a question that clause 79 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 80.
I put a question that clause 80 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 81.
Chair.
Honorable Chair, clause 81, composition of a TVET Assessment Board. Clause 81 of the bill is amended by A, substituting the subclause 3C, the following. 2 persons representing heads of the TVET providers offering health-related programs or courses. B, by substituting for subclause 3D, the following. 3 other persons as follows. In 1, a person representing employers within the public health sector. 2, a person representing employers under the faith-based medical bureaus. And 3, a person representing employers from private hospitals. Justification to specify that the TVET providers on the Health Professionals Board should be those offering health-related programs or courses. 2, to specify the different employers within the health sector who shall form the Health Professionals Board. I beg to move.
Thank you very much, Chair. Chair, I'm not happy with these faith-based organizations. Chair, this clause should remain as it is in the bill. Why? This is because faith-based medical bureaus are not statutory bodies, and there are multiple with faith-based medical bureaus. They are Catholics, Muslims, whatever, many. And therefore, they may impose enforcement and administrative challenges. Secondly, this introduces constituencies and elections, which is not also necessary, colleagues. The proposed insertion is introducing representative of private hospitals, faith-based medical bureaus, and public health sector that limit the powers of the minister to identify and appoint suitable persons to serve on the board. Chair, I submit.
AG.
Right Honorable Chair and colleagues, this is an assessment board. It's an assessment board. And this board, I think you need to let the Ministry of Education manage this assessment board. If you start creating constituencies, as we have seen, certain constituencies are created and they start creating issues within that area. There are so many interested parties in this sector. So what we had is a chairperson, a representative of the ministry, a person representing heads of TVET providers, and then 4 other persons representing employers within the sector. That means you have opened up to all these people. Now, we do not have enough space in this board to accommodate each and every single participant in this area. So if you say today faith-based, then you say private sector, then you say this, they are going to run out of space, and then we'll create a problem. So let's allow it to.
I wanted to know why a representative of ministry responsible for finance is provided a seat in that TVET assessment board. Is there a role we expect finance to play? I would imagine this is a specialized function, and the people who come to that board must play a role which will contribute to proper functioning of the board. Why do we have finance?
We think that this is going to be a very top-heavy financial area, this area of TVET. It's actually quite expensive managing it. But remember, we have started talking about a fund to manage it, to be there. And this assessment board is part of the institution that are running this place. That's why we thought that having someone from Ministry of Finance would be helpful.
And we have a clause on the fund.
Small clarification for the Minister and the Attorney General. You see, we have these health-based, faith-based health centers and even education institutions. And their biggest challenge we have, they are not attached anywhere with the ministry, apart from legislation. But if you bring this close to them, you include them within the bill, they will be part of us. And that was the spirit in which we brought that. My chair can tell you. But Mr. Honorable Minister, the attachment is not there. The attachment is not there.
Honorable Mukatule.
Yes, Madam Chair.
On assessment, you cannot have those faith-based constituencies. It brings a lot of problems. You get it, eh?
Let me accept, but...
because even traditional leaders will come in.
We have at an opportune time, but I don't know why he has feared it, and he's also Catholic, this one. I don't know why he's running away from it. He knows what is happening with the Catholic hospitals.
It's not about Catholics. Yes?
Yes.
It's about the law, it's not about a religion.
Madam Chair, what I wanted to say is, I think what we're discussing here is an equivalent of UNEB, Uganda National Examination Board.
Exactly.
So, Uganda National Examination Board, in this case, what we are coming up with a representation of the board. If there are maybe institutions which fall under this faith-based, say, which are founded by Catholics or founded by Christians or Muslims, I don't think they need to be represented here, because we are talking about technical people who will manage the board. So for me, I don't support the insertion.
So we are maintaining it. Yes.
Madam Chair, given the wise counsel, I do concede on that.
On which one?
On not everything,
No.
about the board.
About the board, not
be represented
finance.
by different faith organizations.
But finance remains.
Finance remains, yes.
Okay. Redraft.
Right, Honorable Chair, we keep the clause 81 as it is in the bill.
Okay. I put a question that clause 81 stands part of the bill. Those in favor say, and the contrary, nay. The ayes have it.
Clause 82.
I put a question that clause 82 stands part of the bill.
Thank you, Madam Chair. Clause number 82C, maybe I need some clarification here because they're saying disqualification from appointment to TVET Assessment Board. C component is saying EOC is an owner of TVET provider or a member of the foundation body of TVET provider. Now, when you see in where we have already passed
conflict of interest.
Conflict of interest. For example, like the minister appoints those TVET assessment board, assuming, let us equate to secondary school. The minister owns a school. He's the one who is appointing those members. It's like he's also the owner in that equation. How can we now balance these two? Number two, a member of the foundation body. Foundation body, for example, if it's the Catholic Church, they have opened,
you know,
and many people
we are
who
not
praise
legislating for Honorable Muingo because he's not going to be a minister forever, even if he remains a minister. But we are making a law for TVET, not for secondary schools.
Yeah, I understand, but I'm trying to bring as a closest example so that we can see how we can see this part of the
Honorable members, I put a question that clause 82 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 83.
Chair.
Right, Honorable Chair, clause 83, tenure of members of the TVET Assessment Board. Clause 83 is amended by substituting for the word 3 to the word 4. Justification, the tenure of the TVET Assessment Board has been amended in 4 years to tally with the tenure of the TVET Council. I beg to move.
No. 2-3.
Chair, I have no objection.
No. No, it is consequential. It was 3. Put it back to 3.
Chair, we put it back to 3.
For purposes of consistency, I concede.
I put a question that clause 83 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 84.
I put a question that clause 84 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 85.
Chair.
Clause 85. Removal from office. Clause 85 is amended in subclause 1E by substituting for the word medical officer the word medical practitioner. Justification, the substitution of the word medical officer with medical practitioner is to align with the definition in the Mental Health Act, Cap 308, which has been adopted in the law. I beg to move, Madam Chair.
Minister.
Chair, I agree with my chair.
AJ.
I agree.
I put a question that clause 85 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 85 as amended.
I put a question that clause 85 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 86.
I put a question that clause 86 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 87.
I put a question that clause 87 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 88.
I put a question that clause 88 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 89.
I put a question that clause 89 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 90.
90.
Madam Chair, clause 90 is amended in subclause 4C by substituting for the word medical officer the word medical practitioner. Justification, the substitution of the word medical officer with the word medical practitioner is to align with the definition in the Mental Health Act, Cap 308, which has been adopted in this law. I beg to move.
Minister.
Chair, I have no objection.
AG.
No objection.
I put a question that clause 90 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 90 as amended.
I put a question that clause 90 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 91.
I put a question that clause 91 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 92.
I put a chair.
Madam Chair, clause 92 amendment, Deputy Executive Secretary. Clause 92 is substituted for the following. Deputy Executive Secretary, the Uganda Vocational and Technical Assessment Board shall have 2 deputies to the Executive Secretary, one responsible for TVET assessment and another responsible for TVET development and management of curricula, the finance and administration. To the Uganda Health
Switch on.
Madam Chair, I'm crossing here with the reservations. Now, clause, I was saying that had gone that to the Uganda Health Professionals Assessment Board shall have 2 deputies to the Executive Secretary, one responsible for nursing and midwifery, and another responsible for allied health professionals. Justification is to specify the 2 deputies to the Executive Secretary under the TVET Assessment Board. I beg to move, Madam Chair.
Minister.
Chair, here I'm not agreeing with my chair. And I'm praying that this clause 92 should remain as it is in the bill, since it captures the technical functions as stated in the draft bill. This is based on the following points. The first one is the proposals being brought are based on existing arrangements which are not consistent with the reform logic. B, clause 91 of the bill provides for the office of the Executive Secretary.
Actually, what is being put here is copied from Universities and Tertiary Institutions Act. Yes, for Deputy Vice Chancellors.
That's why I'm saying it is not it is not in agreement with the spirit of the reform, the bill.
So you maintain as it was?
That's
AG.
Thank you.
Right Honorable Chair, I'm sorry I couldn't cross. I feared to do something unconstitutional, cross the line. So, Right Honorable Speaker, I agree entirely with the Honorable Minister, and I pray that colleagues, as we set out this new structure, we keep it consistent so that we can have easy supervision and management. I pray that the bill remain as it is in the bill.
Thank you. I put a question that clause 92 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 93.
I put a question that clause 93 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 94.
I put a question that clause 94 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 95.
I put a question that clause 95 stands part of the bill.
I'm looking at 95 and examining the functions these people will play. And I think one of them will be curriculum development. And they were responsible for also assessment. Those look to be serious functions and can be heavy on them I don't know, in terms of how the board is constituted, do we think it can perform this function adequately? That is the question I wanted to raise to the minister and the chair of the committee. Curriculum development is a...
You say, when it is 95, development of TVET curriculum, the TVET Assessment Board established under this section 77 of this act shall develop and manage TVET curriculum in consultation with the Sector Skills Experts Committee, TVET providers, and with approval of TVET Council. Now, this is broken down in 2. When you look at 2, the TVET Assessment Board shall, in developing the TVET curricula, perform the following functions.
Yes, Chair. I would like the minister also to clarify on how we are going to have the same board do a curriculum development and the same board is assessing. Because looking at UNEB, who does for secondary schools, and then we also have a different curriculum development center for the same institutions. I find these roles conflicting in a way that you're developing your own curriculum and you're also assessing them at the same time. Could the minister really give us more clarification on that? Thank you.
Yeah, even for the formal education, UNEB sets the exam and then marks it. It's the same thing here. And when they are setting up the curriculum, UNEB actually works with the National Council for Curriculum Development. So they assess it based on that. They work together. That's what they do.
Honorable Apea, UNEB sets exams. It examines. It assesses. It marks. It grades. What differs is who is doing what at what time.
Chair, curriculum development.
Let me first get from local government.
Yeah, thank you, Madam Chair. Madam Chair,
Honorable Zima.
I seem to be agreeing with the issues raised by Honorable Lee and the Honorable Apea on the basis that when you look at the development of curriculum and also the board, ideally, my feeling is also that these two should have been separated. But however, because if you look at this...
Honorable Zima.
Yes, please.
Before you go to however, you first read the whole 95-1. That in consultation with the sector skills experts committees, TVET providers, and with approval of a TVET council. Meaning it is not one person doing one thing. It is in a consultation.
Yeah, I was just trying to finish my statement. What I was trying to bring here is that's why I was saying however. The however part was going to address that some of these activities which appears to be heavy on the two can be managed by bringing in structures below the two deputies. These structures will be put in a way that those manage separate activities. That's what I was trying to bring. Thank you, Madam Chair.
Madam Chair, we don't even need to bother ourselves. The reasons as to why we are establishing this board is to perform these functions. So there is no way these functions can be heavier and more than what they are supposed to do. Otherwise, we will not have the board established.
Chair, if you could just allow me one more time. Time.
One term.
Of course, I'm not one-term MP, that you all know. My point of contention is curriculum development is critical. The reason our education has not been serving us better is
which curriculum development? I want you to be very specific. This is
first of all, I'm speaking broadly about curriculum because it is going to.
Let's speak about this one. Let's finish this law. Let it not be generic.
Okay. Yeah. Let me focus on this particular one.
You get the
law. Get the law. I have it. I've been studying it here. My thinking is we have a body responsible for curriculum development in the country, and we would charge them with the responsibility for developing curriculum. Listen, let me make my case. Responsible for developing the curriculum for these various trades. However, as we all know, curriculum development is done in consultation with the various stakeholders. And that would help us deal with the issues of maybe conflict of interest. You are an examiner, you also developing the curriculum.
In a consultation.
So there will be, consultation is part of involvement of various stakeholders so that they input.
Honorable members, clause 95. I put a question that clause 95 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 96.
I put a question that clause 96 stands part of the bill. Those in favor say on the contrary, nay.
Chair, 96. This type of education welcomes a lot of in-kind contributions. I don't know how they can be captured under this 96.
C. D. Check D.
Any other monies?
Any.
No, in kind, not money still.
It is included.
Okay.
(96) I put a question that clause 96 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 97.
I put a question that clause 97 stands part of the.
Clause 97(2). It contradicts this the Public Finance Management Act. I suggest that we stop at practicable. The Executive Secretary shall have all monies received by and behalf of the TVA Assessment Board banked as soon as practical.
No.
And we stop there. If we add bank accounts of TVA, it will be against the Public Finance Management Act.
No.
All monies are supposed to be banked on the consolidated account.
Advice, under the Public Finance Management Act, the Accountant General can actually set up an account where money can be placed and in compliance with the thing. So we can get the Accountant General to designate this account.
I put a question that clause 97 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 98.
I put a question that clause 98 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 99.
I put a question that clause 99 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 100.
I put a question that clause 100 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 101.
I put a question that clause 101 stands part of the bill. Those in favor say aye, to the contrary, nay. The ayes have it.
Clause 102.
I put a question, Chair.
Madam Chair, clause 102 is an assessment malpractice. Clause 102 is amended by substituting for the word 2 to the word 5. Justification is to provide for a more deterrent punishment. I beg to move, Madam Chair.
Have you matched with the duration of time? The current points.
Right Honorable Chair and colleagues, we do not have any law in this country which prescribes or in any way fetters the ability of this parliament to set any penalty. There is no, this law reform was equating the laws before the coming into force of the law revision. After that, the power under Article 79 is still vested, and if any law was written to that, will be contrary to Article 79 of the Constitution. So it is perfectly fine for a penalty that this to be set by this House. Any penalty. It can even say 1 year with 300,000 currency points.
Okay.
Parliament can do that.
I put a question that clause 102 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 102 as amended.
I put a question that clause 102 stands part of, as amended, stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 103.
I put a question as part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 104.
I put a question that clause 104 stands part of the bill. Those in favor say and the contrary nay.
Chair.
The ayes have it.
Clause 105.
Chair.
I put a question that clause 105 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 106.
I put a question that clause 106 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 107.
I put a question that clause 107 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 108.
I put a question that clause 108 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 109.
I put a question that clause 109 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 110.
I put a question that clause 110 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 111.
I put a question that clause 111 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 112.
I put a question that clause 112 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 113.
I put a question that clause 113 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 114.
I put a question that clause 114 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 115.
I put a question that clause 115 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 116.
116.
Right, Honorable Chair, clause 16, 116, is amended by inserting immediately after paragraph C the following: persons exempted from registration or licensing under section 74. Justification is to provide for persons exempted from registration as prescribed under section 34. I beg to move.
Minister.
Chair, I have no objection.
It's a consequential one. AG.
No objection, Right Honorable Chair.
I put a
Chair, I have an amendment that the clause should read: the council shall maintain a searchable register. A searchable register. The idea is that the public should be able to access this register so that they know if these entities are indeed license providers and things like that. Otherwise, if this information is withheld from the public...
Honorable Oguzli, Access to Information Act is very, very clear on that. So you don't need to emphasize on this one. I put a question that clause 116 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 116 as amended.
I put a question that clause 116 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
New clause.
Chair.
Madam Chair, a new insertion of a new clause, article clause after clause 116. The bill is amended by inserting immediately after clause 116 the following: removal of a TVET trainer from register. 1. Where the certificate of registration of a TVET trainer is cancelled, the council shall remove the name of the TVET trainer from the register of TVET trainers. 2. A TVET trainer whose certificate is revoked or cancelled may, with justifiable reasons, apply to the council to restore his or her name on the register. Justification is to provide for the removal and restoration of a TVET trainer or of TVET trainers on the register. I beg to move, Madam Chair.
Minister?
No objection, Chair.
Isn't that administrative?
We have already passed clauses 65 and 66. And 65 sub-clause 5 clearly provides for the minister to make regulations in respect of suspension and cancellation. Won't this new clause be redundant?
That's administrative.
It would be redundant.
Madam Chair, it's just for emphasis. It has no effect. Attorney General can guide on that.
We can
it has no effect on the bill. It has no effect. Why do you fear one new clause?
Madam Chair, I do concede on that matter.
That there is no new clause.
Clause 117.
I put a question that
Chair.
clause 117 stands part of the bill.
Chair. 117. Right Honorable Chair, I do not see the competencies of giving local government to assess such an important TVET program. In economies like Finland, Singapore, Germany, they are centralized under the Ministry of Education and with very strict instructions. So Right Honorable Chair, that should be actually deleted because it will actually cause a lot of duplication and a lot of substandard things. I beg you to move.
Just Chair, in addition to that, accreditation of these TVET colleges should be done centrally just to stop lack of proper desktop evaluation by local councils. Because competency is very critical when we are accrediting these TVET colleges. Allowing local councils to participate in accrediting TVET colleges might open a gap of allowing bogus institutions that may hamper this whole process. Thank you, Chair.
Maybe they decentralize the council and the district.
Chair.
Right, Honorable Speaker and colleagues. These TVET institutions that we are dealing with, many of us don't even know where they are right now. And they are institutions which are going to the grassroots. And you may find yourself that Ministry of Education at a particular point does not have the necessary reach to get to supervise a specific area. That's why they are saying here, may, by statutory instrument, the functions and powers of council. And the statutory instrument will tell you what powers you can do. It is not necessarily the accreditation. Accreditation may be easy. It is a one-off. But when you finish accrediting, you need to go and check to maintain that these people are actually maintaining that standard. So this power, this authority you give to the minister is to allow them to be reach certain areas where we even today may not have the capacity to reach.
The clause is talking about regulation and licensing. Yes. 117.
Chair, 117. Chair, I want to submit in support of the Attorney General. You cannot make, because we are moving towards, we are advocating for vocational skills everywhere. You cannot make life extremely difficult for people to license these institutions. You can make, for those small ones which we talked about earlier, it's good to make life simple for them. So local governments would be capable to vet them and see the suitability of them and eventually license. It's okay for the minister to devolve those powers down to local government to be able to oversee that. I think this clause is suitable. It's good for us to remain in the law.
Honourable members, I put a question that clause 117 stands part of the bill. Those in favour say and the contrary nay. The ayes have it.
Clause 118.
118.
118, Right Honourable Chair and members, with sincere apologies, I request that in 118D you insert Uganda National Examinations Board. We missed the word national. It's a typographical error. My sincere apologies.
Okay.
In D, we called it Uganda Examinations Board Act. It should have been Uganda National Examinations Board Act.
That will be corrected when drafting, when cleaning.
Right Honourable, I beg that to go on the record because this is what we gazetted. So I'm looking for it to be done as an amendment. This is what we gazetted. We gazetted Uganda Examination Board. So I'm seeking to amend 118D.
Clause 118. I put a question that clause 118 be amended as proposed by the Attorney General. Those in favour say aye, to the contrary nay. The ayes have it.
Clause 118 as amended.
I put a question that clause 118 as amended stands part of the bill. Those in favour say and the contrary nay. The ayes have it.
Clause 119.
I put a question that clause 119 stands part of the bill. Those in favour say and the contrary nay. The ayes have it.
Clause 120.
I put a question that clause 120 stands part of the bill. Those in favour say and the contrary nay. The ayes have it.
Clause 121.
Madam Chairperson, I have looked at the committee report 121, but I have a different opinion. When you look at the Universities and Other Tertiary Institutions Act, particularly Section 130, it did by implication repeal all acts in respect of institutions offering tertiary education. And under that act, a statutory instrument number 14 of 2008 was made, and it lists Management Training and Advisory Center as one of the public and tertiary institutions governed under the Universities and Other Tertiary Institutions Act. And we've passed clause 118 to state that institutions under that act are not applicable under this particular bill. So I would implore the committee to concede, and we have clause 121 entirely deleted from this particular bill, because that institution is now governed under the Universities and Other Tertiary Institutions Act. I so pray.
Thank you very much, Right Honourable Shadow Attorney General. This problem of MTAC was, what can I say, lack of follow-through. Section 130 of the other University and Other Tertiary Institutions Act did actually say that all those institutions became governed under the University and Other Tertiary Institutions Act, but did not close them. They kept them. So what they should have done, ideally, is to move their legal regime to this act, but that was not done. Now the problem with with amendment by implication of repeal is dangerous, because you have actually removed the whole bill, the whole act by implication. Our reading on it, Right Honorable colleague, is that you can amend by implication certain parts, but you cannot repeal by implication. So, because repeal means you take away everything that Parliament had passed. Now, that is not thing. So, this provision here cannot offend what we are dealing with, because the law actually exists. And even if we said that indeed it was repealed by implication, which may be a difficult thing to run with, this will then just simply be superfluous. But if you remove it, and tomorrow another school of thought comes up with a view that you cannot repeal by implication, then MTAC remains. So it will cause that confusion.
Now, what about if we just repeal and leave out the entire clauses 2 and 3, since it is now governed under the Universities and Other Tertiary Institutions Act, in order to avoid the confusion?
I actually thought about that, but I said if we repeal the other one by implication, if we went and did this amendment directly, and there is doubt as to whether it happened under UOSHA, this will take precedence, because it's clear and definite, and the intention of Parliament is clear. So if we find that indeed that argument would stand, then it will only be superfluous. I'm praying that you allow for this. If in any event we find that it was an extra use of words, we will not be hurt, as opposed to the other way around. But also this clause has another fundamental aspect of transfer of MTAC activities in the 2-year period to Nakawa Vocational Training College, because those two are being merged. So to leave it unattended will leave MTAC in the open. So no, this one is repealed, but if you see 2, he says notwithstanding the programs and courses undertaken under the repealed act, which we have just repealed, immediately before the commencement of this act shall continue in force and be transferred to Nakawa Vocational Training. And we have moved also their assets there. Because as a matter of fact, MTAC remained even after UOSHA, the University and Other Tertiary Institutions Act came into force.
You see, Mr. Attorney General, if you talk of a merger, if you look, for example, at clause 77, subclause 3, it clearly speaks of a merger. But this particular one talks of a transfer, and yet you've already recognized its application and applicability under the Universities and Other Tertiary Institutions Act. In my view, if I were you, I would concede section 121 just becomes a repeal of Capital 53, and there may be savings, then you make a reference to the Universities and Other Tertiary Institutions Act, and then leave the rest.
I see what you're saying. What we are doing here is cleaning up a challenge that was created by having passed an act to repeal MTAC, but MTAC, as a matter of fact, continued. It continued existing. So, kind of illegally, so to say. But it is there now, and it has assets, and it has students, and it has things which we cannot just repeal and leave nowhere. So these provisions help us to be able to move these students from this institution into Nakawa. So if we leave it out, it will create more confusion for the institution than putting it there.
Attorney General, actually more to that, if we leave it the way you have proposed, we will have the time, if we need to clean up the law, go back and make the right thing. So for now, the best would be to sustain this, the committee position. We go back, revisit the books. If we need to amend the other law, then we can do that. It gives us the opportunity. So I would propose that we take the Attorney General's side for now.
But Chair of the committee, during the committee period, didn't you foresee this? Yes. Chair of the committee, wasn't this seen during the committee stage?
Thank you, Right Honourable Chair. Right Honourable Chair, I think like we have conferred, let's maintain it. The Honourable Member has pointed out a few things that we need to do backwards to clean this up all the way from the amendment that was done with the University and Other Tertiary Institutions Act, and also going forward to clean this up, which we will do, but this will allow us to move the TVET program and courses to Nakawa. Then the remaining part of MTA, we are going to go back, Ministry of Trade will have to work on how to sort that out. I think.
I put a question that clause 121 stands part of the bill. Those in favor say and the contrary nay. Ayes have it.
Clause 122.
I put a question that clause 122 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 123.
I put a question that clause 123 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 124.
I put a question that clause 124 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 125.
I put a question that clause 125 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 126.
Chair.
Chair, I have clarification for the Attorney General.
Clause 126, Madam Chair, is an amendment, and it's amended in subclause 5A by deleting the words "as the Minister may determine" and by deleting the words "subject to the availability of vacancies." Justification is to make it mandatory for the staff in employment of the Uganda Allied Health Examinations Board and the Uganda Nurses and Midwifery Examinations Board to continue in employment in the Uganda Health Professionals Assessment Board. I beg to move.
Eddie.
Right Honourable Chair and Honourable colleagues, rationalization has the unfortunate reality that some people may actually lose their jobs. So this clause, what you're saying is that everyone in these institutions must be taken over. So what if these three institutions, each one of them had a procurement officer? Must we employ all the three procurement officers in the new area? So that loses the meaning of rationalization.
Attorney General, at this clarification, you need to help me appreciate.
I propose that we maintain the provision as it is.
I wanted you to help me appreciate this. If there are any disputes that should have been arbitrated under those laws we have repealed, or during this transition, how are we going to manage them?
First wait, and I put my question. I put a question that clause 126 stands part of the bill.
Madam
Those
Chair,
in favor
before-
say and the contrary nay. The ayes have it.
Clause 127.
I put a question that clause
Madam Chair, I think it's
127
important
stands
you
part
allow
of the
Attorney
bill.
General clarify.
Those in favor say and the contrary nay. The ayes have it.
Clause 128.
Chair.
You are turning this place into hooliganism.
Madam Chair. Madam Chair. Madam Chair.
Honorable Gwang has something.
Okay.
Honorable Kabanda.
Right, Honorable Speaker. There are some people who come to visit the Answered to see what is happening. The Honorable Member, Honorable Guzili, has just mentioned here that we have hooligans in the House. I request that you use your powers to ask him, first of all, to apologize, but also expunge that from the records.
That's not a Guzili. Can you say hooligans?
Madam Chair, thank you for being such a wise chairperson who allows any accused person the opportunity to respond. I would pray through your medical office that Kabanda should be accorded medical help so that he can hear properly what a member says. What I said was, when we shout aye without a question being put, as you have always guided, we will turn this place a place of hooligans. Therefore,
for me, I've never said hooligans.
You have referred to people who talk. You have often referred to.
Honorable, I've never said anything in regard to hooligans. Please, out of courtesy, and being a good colleague, if you mentioned, I mean, it doesn't cost you much.
Madam Chair, the record is very clear. I have not referred to any member here as a hooligan.
No, you have referred all members.
I have said when people shout without a question being put, it turns us into hooligans, which is wrong.
Thank you very much, Madam Chair. If I heard Honorable Guzuli properly, his comment came after you had posed the question, and most of us said, aye. Then he was like querying your. Yeah, I'm saying what my interpretation,
yes,
that you seem to have turned this house into a house of what? Hooligans.
So who has turned the house into?
Which was very wrong.
Anyway, Madam.
The members, he was keen. After you put a question and people said aye, Honorable Kabanda was shouting aye continuously without you putting a question. Then I said we cannot shout without a question being put.
Honorable Guzuli, just withdraw that statement for the sake of colleagues. It doesn't cost you much. No. Honorable Guzuli, can you kindly, what you said, that we are hooligans?
Madam Chair, if we go back to the Hansard, I have not said so and so is hooligans or MPs are hooligans.
Okay, all members are hooligans, including the Speaker.
This is. I've considered withdrawing that question. If it offended anybody, thank you. I have considered withdrawing that statement if it offended anybody.
Hansard, I want that expunged from the Hansard. Nobody is a hooligan in this house. Pardon? Which? Clause 128. There was a proposal by the committee. So, Silo.
Madam Chair, clause 128. This was for former employers of the Directorate of Industrial Training on permanent and pensionable terms. Clause 128 of this bill is amended in sub-clause 2 by deleting the words "was given an option to serve by the board," and justification is to ensure that the employee is the one to give an option on whether he or she wants to serve on the board or not. I beg to move, madams.
Thank you. Minister.
Chair, I have no objection.
No objection, Right Honourable Chair.
I put a question that clause 128 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 128 as amended.
I put a question that clause 128 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Schedule 1.
I put a question that Schedule 1 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Schedule 2.
I put a question that Schedule 2 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Schedule 3.
I put a question that Schedule 3 You have an amendment?
Madam Chair, I don't have another amendment.
I put a question that Schedule 3 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Schedule 4.
I put a question that Schedule 4 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Title.
I put a question that the title stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Motion for resumption of the House.
Honourable Minister.
Madam Chair, I beg to move the House to resume and the Committee of the Whole House reports thereto.
I put a question that the House resumes and the Committee of the Whole House reports thereto. Those in favor say and the contrary nay. The ayes have it.
Report of the Committee of the Whole House.
Honourable Minister.
Right Honourable Speaker, I beg to report that the Committee of the Whole House has considered the bill entitled the Technical and Vocational Education and Training Bill 2024 and passed it with amendments.
Motion for adoption of the report of the Committee of the Whole House.
Honourable Minister.
Right Honourable Speaker, I beg to move that the report from the Committee of the Whole House be adopted.
I put a question that the report of the Committee of the Whole House be adopted by this House. Those in favor say and the contrary nay. The ayes have it.
Bill's third reading, the Technical and Vocational Education the Technical and Vocational Education and Training Bill 2024.
Honourable Minister.
Madam Speaker, I beg to move that the bill entitled the Technical and Vocational Education and Training Bill 2024 be read for the third time and do pass.
I put a question that the Technical and Vocational Education and Training Bill 2024 be read the third time and do pass. Those in favor say and the contrary nay. The ayes have it.
A bill for an act titled the Technical and Vocational Education and Training Act 2024.
The title is settled and the bill is passed. Honorable members in the public gallery, students and our visitors, you'll forgive us when it is a bill. It's not good always to bring something in between. In the public gallery this afternoon, we have students and teachers from Bulopa Secondary School in Bugabula County, that's in Kamuli. They are represented by Right Honorable Alitwala Kaudaga, Rebecca, and Honorable Kivalia Morris. They have come to observe the proceedings. You're most welcome. Morris, come and greet your people. And he's a very good person. The teachers, you should tell them they bring him back.
Right Honorable Speaker, on behalf of the students and teachers of Bulopa Secondary School and Bugabula South in particular, but above all, Busoga Kingdom, where the Chabazinga is citizen number one, we extended the appreciation for the great role you did when we are getting in Evantu, the most beautiful princess and queen on planet Earth. Right Honorable, we are grateful that you have really given space for these students to be here and watch. These students have benefited more than any other school that has visited, because most of these schools that visit, Right Honorable, they visit when we are in the normal session. They are here for a few minutes. They don't see what these ones have observed. Now these ones have a story to tell. Yes. So we are very grateful. Those are the the speakers in the next 20 years. They are the presidents in the next 20 years. And they are the members of parliament in the next 20 years.
And they are the ones who are going to benefit from this law.
Yes.
That we have passed.
So, Right Honorable, we are very grateful. Students of Bulopa, this is your parliament. The speaker has done everything to make sure this parliament is moved to the lowest person. That is why you are here. Some students are from senior one who are there, Right Honorable. We are very grateful. Thank you very much.
Thank you so much. Honorable members, in the VIP this afternoon, we have a delegation from the Parliament of Kenya. Karibuni sana. They include Mr. Ochola Sylvester Ouma, the head of sports and wellness unit, and Mr. Albert Walusuna, the wellness therapist. You're most welcome and thank you so much. I know you're here because of sports, but Team Uganda is very ready to beat Kenya. And but we are brothers and sisters. My Minister of Sports wants to welcome you.
Madam Speaker and colleagues, first of all, for the spirit of the Pamoja bid and for the purposes of AFCON 2027, and for purposes of CHAN 2025, let me begin by congratulating our sister parliament of the Republic of Kenya for supporting this initiative led by you, Madam Speaker, here for Uganda, your colleague in Kenya and Tanzania. For the record, Coach Ochola is one of the longest serving parliamentary coaches in the East African Parliamentary Games, because I joined this parliament in the 9th parliament when Uganda hosted the games here in Kampala. If I may recall, and he knows it, in Ambole it was Uganda 7, Kenya 0. And I'm happy that we will be meeting in Mombasa soon. Madam Speaker, I've been reliably informed the opening game is the defending champions, who are ourselves as Parliament of Uganda Football Club, and the Parliament of Kenya, who are the host. Coach Ochola, we meet in Mombasa, but we are ready to remain the champions of East Africa. Welcome to Uganda. Congratulations. Thank you so much. Karibu sana.
Thank you so much, honorable members. Honorable members, I just want to re-echo in the spirit of collegiality and spirit of keeping decorum in the house. let's learn to have respect for each other. Because today we are here, tomorrow we shall meet in the streets of Kampala when some people don't come back and others come back. And I will still remember how you called me a hooligan, how you called me whichever. Let's live together in harmony. Let's live together in harmony. And as I said before, this is your second home. If you cannot have peace in your second home, then where will you ever get peace? If you have frustration from somewhere, when you enter here, first keep off your frustration and then put a smile on your face for the sake of legislation. And I want to urge all of you, we are all brothers and sisters. And we are all equal in this house. Nobody is bigger than the other. And we should learn to love ourselves. Let it be today when Ethel is not in the house, everybody is missing Ethel. But let it not be like, if Ethel is not there, it is good riddance, whether she comes or not. Like I always miss Honorable Aisha. Whenever she's not there, I miss her. You get that kind of, like when all of you, if you're not in the house, I miss all my members of parliament. Because we should live together. We should love each other. I want to thank you for the bill. And as you go to your constituencies, create awareness about the bill. Let our children out there not remain doing nothing. When we have the bill in place, we have the money to fund the bill, and let these children go and do skilling, go and do all what they can do to avoid redundancy. I want to thank you. And maybe lastly, we have been having amendment of the rules of procedure. We will make the rules of procedure stringent, so that people should learn that when people are watching us outside there, they should know that they are watching honorable members of parliament, not horrible members. Thank you. Yes, Honorable Minister.
Thank you very much, Madam Speaker. Madam Speaker, on behalf of the Ministry of Education and Sports, I want to thank you and dear colleagues for a job well done. Thank you for the sacrifice. Thank you for the guidance. God bless.
Shadow.
Thank you, Madam Speaker. I want to thank the Minister and the whole team of members of the committee. Sincerely, we have moved very well. And as we have always said, that whether you process a bill in the committee, you like it or not, it will be subject to some issues here in the House. Like I was asking my landy friend here that we wanted to save these people, the nurses and others, those who have been serving. And you said the rationalization, people will lose jobs, but it's not an absurdity because it must be sustained. But we want to thank you very much. Madam Speaker, I remember I was here, I was saying that 2 days are not enough. And you took us somewhere, we sat, processed the bill, and we are here.
By the way, I want the forensic bill.
So, thank you very much.
Defense and Internal Affairs.
And Madam Speaker,
there is no saying 2 days are not enough,
yes.
And I am very happy with your team.
Yeah, I want to allow me to thank the Attorney General, because I've been in this house, but this is the first time, and he can bear witness, whenever we want the Attorney General in our committees, he's there to respond to our issues. But you know, we have the best Attorney General. I want to thank you very much, Mr. Chiriowa, and listening to us.
Mukatuliki.
Thank you very much.
Well, you know, we have the best Attorney General in the country. That one is cannot be doubted. Yes, Chair.
Madam Chair, I would like first of all to thank the committee members of Education and Sports. And I would also like to thank you very much for the resilience and the stance you had on us. You said 3 days. And when the Honorable Semu came here to plead, you said 3 days. And I also became tougher on my friends, and I would like to appreciate for the resilience that this bill has been passed. We are very grateful.
Thank you. Honorable Member, thank you for the afternoon. I now adjourn the House Sunday.